Good morning, everybody. Happy Thursday. Welcome to TCF Live. It is a very, very quiet start to the morning in Courtlandia, so I'm actually going to start us with Judge Middleton and a sentencing that he did yesterday. So we're going to start in the Wayback Machine, but you'll notice it's paused because before we go there, I want to show you something. You have been requesting it yesterday in the fit of rage of fixing everything. I made it happen, ladies and gentlemen, the Ellie cam. You'll notice she's currently sleeping in the bed down on the floor, so we can check in on her from time to time now, the Ellie cam. And yeah, she just moved, so you know it's live. Okie dokie, let's get going, Judge Middleton.
Good morning.
Good morning.
This is the time and the date set for sentence in the matter of People versus Carl David Lockhart. File number is 26147FY. Are you Carl Lockhart?
Yes, Your Honor.
We've met, but I need to identify you for the record. You're here with your lawyer, Ms. Rhonda Ives. Also present is Matthew Huff from the Probation Department, and Abigail Stoll from the prosecutor's office. This matter is complicated. The defendant was charged with domestic violence as a felony, third offense or subsequent offense. It was reduced to domestic violence, second offense, and was scheduled for sentencing today. He pled guilty to DV second on February 17th. The defendant is on probation to Judge Pattison in a malicious destruction of property case, I believe is the underlying charge, for 24 months in file 251367. This plea violates the probation in the underlying case, and I believe we discussed that at the time of the plea. Mr. Lockhart, do you understand that this plea would be a violation of your probation and the earlier probation that was from December? Being convicted of an offense, a criminal offense while you're on probation, is a quintessential violation of probation. Do you understand that?
Yes, Your Honor.
And you're willing to proceed with sentence here today?
Yes, Your Honor.
All right. Now, let me give a little background and some disclosure here. I have exchanged emails and discussions with Mr. Huff, and he stopped in this morning to talk to me. Neither counsel was present. We reviewed his probationer status report, and he has 2 incident reports from the jail. Rhonda, do you have copies of those?
I do not. I don't know who prepared them, but no one sent them to me.
Well, I was just handed them a minute ago. Abigail, you probably don't have them either. Would you give these to Ms. Ives? Lauren Frank, bless her heart, has also been heavily involved in Mr. Lockhart, as well as Stoney Summey, our our veterans coordinator. And we've run out of good answers. No, is it doing that thing again? Just a minute. Rhonda, tap your microphone. It's been doing a thing where it just locks on me. I'm gonna put it on overall. Let's try that. At any rate, the defendant is presently on a probation to Judge Pattison. There was an earlier domestic violence where they attempted to get him into a aftercare treatment program, but the defendant did 93 days rather than enter the program. Then he was placed on that probation, and after he was released, he got arrested on this offense on January 29th. He has been in custody since January 29th, and the matter, I think, has 41 days of jail credit in this case. defendant is already on probation to Judge Pattison. And when this case is completed, will probably be subject to a probation violation and attempt to find a solution. This is a troubling case in that it's at least the defendant's third assaultive case. It was a serious assault on the complainant, Ms. Kloosterman, and it isn't the first one. I handled one back in 2022. Mr. Lockhart is an intelligent man. When I see him, he's always calm. The two incident reports that Matt provided, for whatever they're worth, indicate that he's continued to be involved in assaultive behavior at the jail as recently as earlier in the month of March. So he is a defendant without a clear solution. But people are looking for one, and I commend them for that. Ms. Ives, what would you like me to know?
Well, Your Honor, without getting Mr. Lockhart into some type of inpatient treatment where he's reprogrammed, has a new set of goals, a new outlook on life with skills to address his substance abuse disorder, his own mental diagnoses, which I will not state on the record, but the court certainly has the report in front of him, or in front of you, Your Honor. So I think that he needs to be cognizant of all of these things that have impacted his life, or the recidivism on this for Mr. Lockhart is just not going to end. I just can see him continually back before, Your Honor. I was part of the case with Judge Pattison. I had been representing Mr. Lockhart up through the final sentencing, in which she had, I think Attorney Harden took over at the sentencing because she had another file with Mr. Lockhart as well. So she completed that file, but there's just, I think giving him a 6 months jail sentence doesn't necessarily help us at this point. He needs a program, he needs a plan. And that's what I would add. I know he's interested in treatment. He has indicated a willingness to go. He was indicated a willingness to go on our last case. Here's the problem. He got released. And once released, reverted back to whatever he had been involved with. And so here we are again. Thank you.
Well, Judge Pattison, and I've tried to fashion a sentence that he couldn't get out. He had to go directly from jail to treatment. But somehow the maximum was served minus good time or something, and he got out. And then here we are again. Mr. Huff and I, for what it's worth, don't disagree with what you just said. The easy thing to do would just give him 365 days in jail. I'll be retired by the time he gets out, and it'll be somebody else's problem. But I'm afraid he's going to kill somebody or seriously hurt them. And I don't want to throw in the towel. I want to have some sort of a treatment option rather than just give up. Ms. Stoll, you've inherited this difficult case. Do you have any input here?
It is a complicated case, Your Honor, so I'll leave it to the court's discretion.
Well, Matt has a really good handle on this. Part of the problem, Mr. Lockhart, is some of your cases have been with me and some have been with Judge Pattison. It's sometimes just how things are assigned. I have dealt with you back on Rock River Avenue in 22, maybe another case after that. I don't remember if I had the drinking driving case or Judge Pattison did. So you're on a probation right now in file 251367 for 24 months. That is a 1 year probation. I mean, a 1 year maximum sentence. So I don't need to put you on another probation. You're already on one. And you've got about 270 days or so left in the 1 year sentence. Mr. Huff, you've got more insight maybe than anyone. You've had a number of conversations with Mr. Lockhart. You did a pre-sentence report in the previous case. You've been tracking this. You found the incidents from the jail. What's your input here?
Well, Your Honor, I've been, as Ms. Ives and the courts already reflected, we've all had some history with Mr. Lockhart here. I feel like I've probably been his biggest advocate over the last 6 years as he's been coming into contact with the courts with new cases. And I've tried to work with him in the past on meeting rehabilitative goals. And unfortunately, we're moving in the wrong direction here. I'm very concerned that he had this new domestic violence within basically a month of being released with the same individual.
And it was a bad one.
It's a bad case. I'm concerned about the jail reports that I found out that this was going on at the jail. I don't know the context. I don't know if someone's calling them names. I don't know if somebody's hitting it first. They reviewed the footage and they say that Mr. Lockhart was the aggressor. I don't know. With that being said, I don't know that I'm ready to just pull the plug. This might be about as close as we can possibly get before there's just no consideration for probation anymore. But if the court's inclined to give him a jail sentence here, and he serves that jail sentence without any sort of issue, I would not object to his probation continuing on the other file, and then maybe we can get him connected to some long-term rehab. If he does that, maybe he can get his life turned around. But he's gonna have to come to terms with the fact that he's gonna be separated from his local environment, from the people he knows and loves, and he's gonna have to just go out on a limb, take a step of faith, be in an uncomfortable environment, and take full advantage of that. The biggest concern I have right now, if he were to be placed in a rehab center, especially one that is a relatively new resource for us at Guiding Light in Grand Rapids, is that if he's not ready to do that sort of stuff, as indicated by these jail reports, we don't want to send him up there and then have that resource go away because we're sending bad referrals that are just causing problems. So it's a concern. I don't know if that's what's going to be on, but it's just some of the things that factor into the equation that I think is worthwhile mentioning. But yeah, I mean, ultimately, this is a bad case that deserves some sort of a consequence. I'm inclined to work with him if he can kind of clean up his act in the near future. He has the pending probation violation that will be scheduled. And I think that's all that I have to offer the court today.
All right. You make a good point. We're always looking for placements. Ms. Frank and others, we've got a good working relationship with a number of places, Bear River, some others. I don't want to burn the bridge if we send Mr. Lockhart up there and he spectacularly fails. They might not take anybody else from our county. I'd like to think that he would go there and be successful. Mr. Lockhart, there's a lot going on here. There's PTSD. There's probably a bipolar disorder or other mental health issues that your lawyer didn't really want to go into all of it, but also there's methamphetamine, which it's hard sometimes to tell methamphetamine from mental illness, and methamphetamine can trigger mental illness. And I think methamphetamine's been in your background for a long time. Then you throw in opioids, you were dabbling in heroin, and that didn't hopefully stick. But you got a lot of anger. You're one of the angriest guys I've seen in a while. But when I see you and when Matt talks to you, you're intelligent, measured, you accept responsibility and all this stuff. I don't think you've denied any of it. even this most recent one, you acknowledge you punched her in the face. So you've accepted it, ownership of it, but what do you want? You're on a treadmill that never turns off. So what would you like to tell me?
Honestly, Your Honor, I was thinking that this guiding light was going to be pretty much my last effort at anything. Like chance for substance abuse, counseling, treatment, mental health. I mean, the program at the end of it was even going to help out with my housing. And
Yes, and
job
employment.
Yeah, it was pretty good. I mean, I've been dabbling in the Bible since I've been in jail, and it was even Christian based. I just want to be a dad again, honestly, Your Honor. Like through all this, I'd like to just be able to go back to boring, to be able to sit on my couch and play video games and watch my kids. Like, I don't want to be this in and out of jail, having my mom come here and see me do this all the time.
Well, those two, playing video games and watching kids, are not two compatible occupations.
My daughter plays a little bit herself, yeah.
Well, Centerpoint is not a dead issue. One concern I had is if I use up all of Judge Patterson's jail time, he doesn't have much time to work with. I think the way Matt and I calculated this, when I was thinking about my sentence, he'll have at least 180 days or so to deal with. I'm gonna order 90 days, credit 41. That leaves 49 days to do minus good time. In the meantime, this conviction violates your probation. Mr. Huff is gonna file a probation violation petition. Then Judge Patterson can see you at the end of this next 40 days or so and make a determination whether residential placement would be appropriate with jail hung over the top of your head. So there's no sense for me to do another probation. I've been struggling with this since last week till I finally understood the whole ramifications of probation you're already on. So the fine is $0. I'm gonna waive the attorney fee as well. There's $125 of minimum costs for 2 additional days. So 49 days minus good time is approximately 40 or 42 or so. That's certainly enough time to file a probation violation petition, bring the matter back before Judge Patterson. Lauren at the jail is still plugged into this. This gives her 40 days. We're also going to see how you do at the jail. I didn't like reading those reports. You can keep them. But in one of them, they say you were bullying somebody else and you were the aggressor. You're not going to last very long in a residential treatment program for that mindset. And at some point, if one of these happens again, the prosecutor's not going to reduce it to a misdemeanor. They're going to hold the line and they're going to send you to prison. You want to be a dad, and I think that would be best for all concerned.
Your Honor, can I give these pages to,
Do you care, Matt, whether he sees those reports? I don't know if he's entitled to have those or not.
I don't know if he's, I mean, I don't have any objection to it. He's gonna see them eventually. I don't know if the jail has any policy on the incident reports.
Maybe the jail doesn't want him to have them, but the allegations are that you can ask for them at the jail. Once you return them to Mr. Huff, and you can share them with Judge Patterson.
and I will get a copy of them.
Yeah, before you
For
leave
the
here.
probation. Are you on the probation case?
I don't know. I don't even, have you even filed a
Yeah, it's
probation?
filed.
It's
It's
filed?
just the petition hasn't been issued yet.
Oh, okay. I don't know if I'll be appointed or not. Jordan Harden was the one that did the sentencing in that case.
I think
so-
Jordan's
If
got
you
that case.
Find it relevant and you want these, I can get you a copy.
Yeah, I would like a copy of this. Thank you.
Rhonda, before you leave, could you, Mr. Lockhart, you're good to go. I hope you can get some calm time at the jail and they can get you into a treatment program and we can alter the course of history. One of your old clients, Mr. Bo Hike, turned.
All right, everybody. Good morning once again. TCF Live on a Thursday. Thank you all for joining me. I hope you're off to a good start with your day. Great Granny, a little while back in the chat. I've lost it now. Oh, here it is. It's a moral question before me. Should I find joy watching someone else's misfortunes that get them into a YouTube courtroom? Nah, they should just have not done the crime. Well, it's interesting that you bring that up because tonight on Sidebar right here on this channel, we're going to kind of talk about that very thing. Streaming justice, transparency, or exploitation. You know, Judge Boyd lost her seat because her opponent in the primary called out the fact that she streams her court and how that's not fair and all that kind of stuff. There's often a lot of weirdness going on and a lot of strong opinions. So that's what we're going to talk about tonight on Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel. So check that out. And for those of you just joining, we have a new feature this morning because it was requested a lot. Come on, where did you go? There it is, the Ellie Cam. So when she's sleeping next to me, we can now see that in beautiful 1080p action. So that's your co-host. She's given up on you and gone to bed. Okie dokie. Let's get out of the Wayback Machine and go live. We'll go to Allegan County, Michigan. This is Judge Scoselis.
At that time, the prosecutor's office requested we set this for sentencing at a later date for crime victim rights purposes. And is Mr. Blair still with us? Mr. Blair, is Tina Caldwell present at your office, or has she filed any impact statement?
She has not, but she indicated she does not want any restitution, Your Honor.
Okay. And reviewing the file, the original pretrial conference sheet did not contain any specific recommendation for sentencing. So with that, Mr. Caldwell, this is your chance to tell me anything you would like to for your sentencing this morning.
No, I don't want to add nothing.
Ms. Vogel, on behalf of Mr. Caldwell.
Thank you, Your Honor. Mr. Caldwell has a strong support system in his family that have been helping him through a lot recently. He's been spending a lot of time with his brother, spending time with his mother, who's in her late 70s, helping her around the house. She is in the hospital today, and he's going to be a big help for her when she gets out. We would request minimization of fines and costs, as Mr. Caldwell is on disability for several reasons. Additionally, malicious destruction of personal property is not considered a serious misdemeanor under MCL 780.811, and therefore there is a presumption under MCL 769.5 of non-jail and non-probation sentence for those charges. Thus, we would request fines and costs only in this matter and would request minimization of fines and costs due to Mr. Caldwell's limited financial situation. Thank you.
On this charge is $200. Court costs are $200. State costs and fees $125 for a total of $525. Court file shows you released in the Allegan County Jail on a $300 personal recognizance bond. So all of that is due. We'll put that out for payment over the next 3 months. Court staff will mail to you a judgment of sentence, which will indicate just what I said, that you received a sentence of no jail, no probation, fines, costs only, no restitution was requested and none is being ordered, and that you have 90 days, 3 months to take care of the fines and costs. With that, you are free to hang up from the court proceeding this morning. Expect that in the mail. Good luck to you, sir. Thank you, Ms. Vogel.
Thank you, Your Honor.
And then I have Kenyon. Hi, Kenyon, can you hear me? You have to unmute.
Okay. Yes, I can hear you. I'm trying to figure out how to turn my camera on real quick. One second. Sorry about that. Okay, is that on now?
No.
Okay. Is it on now?
The record on 3 separate files on People versus Sky Thomas Kenyon. File 254319 SD, file 254320 ST, and file 254335 ST. All 3 of these cases are based on a single citation that was issued by the Allegheny County Sheriff's Department on charges of operating while intoxicated, second offense, driving while his driver's license was suspended, and having a plate on the vehicle that was not assigned to that vehicle by the Michigan Secretary of State's office. Pre-trial conference was held in this case back on January 16th. At that time, the defendant entered a plea of guilty to the charge of operating while intoxicated, second offense. He entered a plea of guilty to the charge of driving while his license was suspended. And he entered a plea of guilty to the charge of having unlawful plate upon the motor vehicle he was driving while suspended and under the influence. Reviewing his criminal background, I ordered a pre-sentence investigation in this case and a substance abuse assessment as required by law for the operating while intoxicated second offense charge. Both of those have been completed, so we are able to proceed to sentencing this morning. Ms. Fogel, regarding the pre-sentence investigation, have you reviewed that with Mr. Kenyon? If so, any additions, deletions, or corrections to it?
No, Your Honor. And we have reviewed it and we have no corrections. Thank you.
The original pretrial conference sheets did not contain any specific recommendations for sentence. So, Mr. Kenyon, on all 3 of these cases, operating while intoxicated, second offense, driving while your license was suspended, and having an improper plate upon the motor vehicle you were driving, this is your chance to tell me anything you would like to for your sentencing.
I think that everything's been covered already that I need to know or you need to know. Thank you.
Ms. Vogel, on behalf of Mr. Kenyon for sentencing this morning.
Thank you, Your Honor. At the time of this incident, Sky had been unemployed for a period of time and was feeling very depressed and aimless. He had been drinking late at night, and he was talking on the phone with a young woman who he was interested in, who wanted him to come over. It was the first positive thing to happen in his life in a very long time, and he reacted without thinking, just trying to chase that feeling. He knows he never should have left the house that day. Sky has a very strong connection with his community in Mount Pleasant. He enlisted in the Navy for 3.5 years immediately following high school, but he returned home after finishing his military service and has lived there ever since. He has a strong family support system made up of his mother, father, brother, and grandmother who all live in that area, and his family gathers every weekend for family Sunday dinners. Sky shared that these dinners are alcohol-free and listed his family as his strongest support system. His 17-year-old son also lives 10 minutes away from him in Mount Pleasant, and Sky has a strong relationship with his son who stops by to see him almost every day. In terms of his substance use history, Sky has shared that on his prior OWIs, his BAC was very close to a 0.08 in terms of both prior charges, which obviously is still above the legal limit, but was very close to that level. Sky reported that he used to drink regularly on the weekends and would drink approximately 6 beers per occasion, but did not have an increase in tolerance or use over that time. He successfully completed probation in the past after his first OWI and stayed sober through the course of probation and for a short time after. He also participated in a long-term residential treatment program about 2 years ago where he stayed for approximately 45 days. He has been very committed to his sobriety. He's had setbacks, but he has been committed to getting better. This incident was a huge wake-up call for Sky. Since that day, he started going back to AA meetings with his brother, who's been sober for 16 months and a great support for Sky in his own sobriety journey. At this point, he has not consumed alcohol since this charge and is resolved to stop drinking going forward. He is currently attending AA meetings about 3 times per week with his brother, who provides transportation and accountability for Sky. He now has 70 days of sobriety. He also has a very strong employment history. Following high school, as I said, he enlisted in the Navy, served 3.5 years. After that, he spent 6 years working on oil fields in North Carolina, Pennsylvania, and West Virginia, while living in Michigan, traveling around to these various states for work. He also ran his own drywall business for at least 6 years and successfully managed a staff of 6 employees while also handling the day-to-day operations of his business. He now does work full-time again with significant overtime opportunity at Robinson Industries as an extrusion operator, which is a position he has held for about 2 months now and really enjoys. He works full-time, as I said, and often works overtime, choosing to work extra hours on Saturdays and Sundays to save up extra money to move into his own apartment. Right now, he is living with his mother, who is a great support system for him, as I said, but he is excited for the chance to live on his own and take further control of his life. This job and his sobriety have given Sky a renewed sense of purpose and pride, and he is motivated by the great feeling of a hard day's work that he missed while he was unemployed, and by his desire to be a positive role model for his 17-year-old son. Finally, Your Honor, driving while license suspended, revoked, or denied, and unlawful use of license plate are not considered serious misdemeanors under MCL 780.811, and therefore there is a presumption under MCL 769.5 of non-jail and non-probation sentence for those charges. Thus, under files 254335ST and 254320ST, we would request fines and costs only in this matter. For file 254319SD, in which Sky has pled guilty to operating while intoxicated second offense, we would request the court impose no more than the minimum required 5 days of jail, and that the court allow Sky to serve the minimum 5 days jail associated with this charge through the weekend community service program so that Sky is able to keep his job with Robinson Industries and continue on a positive track. Thank you, Your Honor.
So Kenyon, as you probably know best, you should be in circuit court being sentenced for a felony charge right now. This is your 3rd drinking and driving conviction, and you're still here in district court on a misdemeanor charge. The pre-sentence investigation shows you have a prior conviction for operating while intoxicated, and I don't have the court here any longer, but in 2017, a second conviction in 2022. This arrest was in 2025. So within an 8-year span, you had 3 arrests for drinking and driving offenses. For whatever reason, the officer in this case didn't catch that. She wrote this as a misdemeanor for a second offense. The prosecuting attorney's office either didn't catch it or chose not to charge you as a felon. But again, you have 3 convictions now within an 8-year span, 3 in your lifetime for drinking and driving as a felony. And for whatever reason, you're here being sentenced on a misdemeanor charge. So, sir, you are now in a very, very, very small group of people here in Michigan who have 3 or more drinking and driving convictions on their record. At the time, you couldn't drive at all. As soon as you got behind the wheel, period, you were breaking the law because your driver's license was suspended. The car you were driving wasn't street legal either. So vehicle wasn't legal. You weren't legal to drive it, and you drove it the 3rd time drunk. Reviewing the pre-sentence investigation, again, it shows the same things I just mentioned: an operating while impaired conviction 2017, an operating while intoxicated second offense conviction in 2022, possession of methamphetamine in 2023, open alcohol in a motor vehicle 23, a domestic violence conviction in 22, a second domestic violence conviction in 25, and 3 unrelated misdemeanors for 2 of them for plate violations that you have here, and not having insurance on the motor vehicle. You have a prior conviction for a felony, 7 prior misdemeanor convictions prior to this, and now pick up 3 more. So you'll now have a total of 10 misdemeanor convictions. You've been on probation, it looks like, over and over again. You were on probation in the 75th District Court in Middleton. You were on probation to the 76th District Court in Isabella County. Again, on probation to the Isabella Circuit Court, District Court. Looks like on your felony charge, you are on probation to the 21st Circuit Court. A couple of these were successful. 1 was revoked. So you've had a lot of government assistance trying to take care of your, looks like, both drug and alcohol problems. Again, in this case, you have now 8 felony and 10 misdemeanor convictions. This is your 3rd drinking and driving conviction. Again, at the time, you had no right to drive at all because your license was suspended. You live up in Mount Pleasant. I don't know what happened here, only you do. It sounds like you got a call from somebody, decided to come to Allegan County from Mount Pleasant, from what I've just heard. In any event, you were arrested on Christmas Day at 3:45 in the morning here in Allegan County and arrested on your 3rd drinking and driving offense. Sir, given your record, given all the chances you've had before on probation, and now have a 3rd conviction for the very same thing here in Allegan County, clearly you are a public safety risk because you continue to drink and drive after having that type of a record and having all the services that have been provided. And it sounds like all the things you've gone through on your own on top of that, and it doesn't sound like you're able to not drive after drinking, which is all I'm concerned with. The drug and alcohol use is between you and your own body, but when you get behind the wheel and drive from Mount Pleasant down to Allegan, then it becomes a public safety risk and a public safety issue. So on this charge of operating, well, let's take it this way, try to be easier. On the charge of driving while your license was suspended first, on that charge, we'll impose a sentence of fines and costs only. On the charge of driving while your license was suspended, the fine is $200. Court costs are $200. State costs and fees are $125 for a total of $525. We'll put that out for payment over the next 3 months. On the charge of having an unlawful plate upon the motor vehicle that you were driving while suspended, we'll also impose a sentence of fines and costs only. On that charge, they are a set fine of $195. We'll also put that out for payment over the next 3 months. The charge of operating while intoxicated, 2nd offense, will place you on probation for a period of 2 years. And that will be with substance abuse counseling as directed by the probation department. Standard condition of probation on this charge is that you not possess or consume any alcohol, marijuana, or illegal controlled substances other than those prescribed to you by a medical professional. They will have the authority to check you for that here at the probation department, have you checked by the police at your home. And for the reasons as already stated on the record, I'm going to order physical monitoring for alcohol consumption for the first month of the probationary period, utilizing either Scram or SoberLink at the discretion of the probation department. On this charge, will also require attendance at a victim impact panel. Your driver's license either is or soon will be gone for the next year because of your conviction. Specific condition of your probation is that you not operate a motor vehicle until you obtain a valid license to do so from the Michigan Secretary of State's office. So driving while on probation at all would be a violation of your probation. The charge of operating while intoxicated, 2nd offense, the fine is $1,000. Court costs are $400. State costs and fees are $125. There is a $720 oversight fee for that term of probation and a $100 fee for the substance abuse assessment that was done through the court for a total of $2,345. Court file shows on the misdemeanor charge, you were released on a $500 personal recognizance bond, so all of that is due. You will have the entire time on probation to pay that amount on a monthly payment plan set up through the probation department. The charge of operating while intoxicated, 2nd offense, vehicle immobilization is mandatory. We checked. There was no record, according to the Secretary of State's office, of the vehicle you were driving, which again just means you were driving a vehicle that wasn't street legal, but we don't have any idea who the titled owner of it was. So accordingly, an immobilization order cannot be entered on this case. Finally, Mr. Kenyon, for the reasons as already stated on the record, I'm imposing a jail term of 60 days in the Allegan County Jail. I'm showing credit for 1 day already served. Need to report to the Allegan County Jail by next Friday, March 20th of this year at 3 o'clock in the afternoon, or after that time, a bench warrant will be issued for your arrest. will indicate that I have no objection to Mr. Kenyon having work release if he qualifies under the jail's work release program. I'll also ask the probation department to set this for an internal review the following Monday, March 23rd, to verify that he's in custody at the Allegheny County Jail on that date. Finally, as to your probationary sentence, required to advise you pursuant to MCL 771.2 that you are eligible to be discharged at the halfway point of your probationary sentence if you have completed all the terms and conditions of your probationary sentence at that time. So in your case, probation could be concluded in as soon as 1 year. Sending your files down to our probation department at this time. They're going to contact you on the telephone to set up your probation order. What telephone number can they reach you at this morning?
989.
Sorry, 989-93. You are free to hang out from the court proceeding. Be available at the telephone number you just gave us. The probation department will contact you at that number shortly. Good luck to you, sir. Thank you, Ms. Fogel.
Thank you, Your Honor.
Thank you.
Once again, everybody, good morning. TCF Live. It's Thursday. Barbara, thank you for the $5 super chat, and thank you for gifting the 5 memberships. You say, Dan, glad you got things fixed. Dan is glad, too. I hate missing days, especially because of tech. But I've totally redone everything, wrote some custom scripting, and we should have no further issues of that kind anyways going forward. But I'm sure something else will break, because that's how this goes. Let's change things up. We'll stay in Michigan, but let's go see what's going on with Brian Oakley.
Counsel, is there a blood test result in here somewhere?
Blood draw.
All right. Based on that, hey, Jamie.
Yes, sir. Back to counsel.
Based on that blood test result and what I've read in the report, I can accept the plea to the impaired driving charge. I will dismiss the original charge of intoxicated driving and the accompanying civil infraction. We've already got you on a personal bond. I'll continue bond, send you downstairs to make an appointment with the probation department, and then we'll see each other, I don't know, 4 or 5 weeks. The 3 of us will talk about that report. Questions? Counsel, anything else?
No, Your Honor.
You two have a great day.
Your Honor, I had another case.
Name? Got it right in front of me. Wallace? Do I need a prosecutor for this one? Do I need a prosecutor?
Okay.
Are we ready on Williford?
Yes, Your Honor, ready.
Good morning, counsel. Your appearance for Mr. Williford.
Good morning, Your Honor. Leanna Belcher on behalf of the defendant. Sir, please state your name for the record.
Good morning, Your Honor. Mario Williford.
Good morning, counsel. What do we got?
Your Honor, we have a GROFF license not valid that was in warrant status. I'm asking for the warrant to be recalled. My client is in the process of trying to take care of his outstanding tickets so that he can potentially resolve this with a plea. I'm requesting another pretrial date.
Okay, so the plea agreement I've got for a guilty plea is going out the window.
Yeah, Judge, they want him to plead as charged. Our hope is, and he's paid, I believe he said around
That's all right. You
2,700.
had me at hello. I'm just confused by the paperwork I'm looking at.
At 9:10, Leanna is already MIDC that day with Judge Martin.
All right, April 23rd. What time? I'm sorry.
9:10.
So that's a Zoom?
It-
All right. You got that, Mr. Williford?
Yes, sir.
All right, we'll mail you a notice. Counsel, anything else today?
No, Your Honor, not on this matter. Thank you.
You're welcome.
Thank you.
Oh,
Thank
Mr.
you. Attorney.
Williford,
Yes,
you owe us money.
I know.
Are you working?
No, not at the moment.
When's the last time you worked?
Last week, I'm returning back to work. I just had got out of jail, so that's why I'm not working.
Okay. Can you commit to some kind of regular payments, either weekly, bi-weekly, or monthly?
Yes, I can.
Well, how do you want to do it? How much? How often? When can you start?
Bi-weekly, and I can start today or whenever.
You tell me.
Today,
How much?
I can start off with 100.
You're sure?
A positive.
All right, you gonna do that online then, or you gonna come in?
I can either one.
Say again?
Either one, but I can do it online.
However you want to do it. All right, I made a note. Good luck.
Thank you.
Thank
All right,
you.
appearances
Thank you,
on
Tony.
Wallace, please.
Jerry Davis, Electric, Pete, Bristol, Southern, Florida, about John Wallace. Stands.
All right. Thank you. All right. What do we got today?
Public motion is best, you're on, let's go with Carter, follow response. Hearing.
I don't know that I've seen the response. I don't think I've seen it, and it's not in the file. Do you have a copy? If- let me have it. If you guys just give me a few minutes. Yeah, sure. Let me go through that and then we'll talk.
One smaller.
All right, a pause in the action with Judge Oakley. So let's go over to Judge Simpson. He's just getting his day going.
Conflict arise, exists today, but should a conflict arise, we will waive said conflict and please ask this honorable court to please hear all matters before.
Court for its part also does not believe there's conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court calls the case of the People versus Evan Sherbert.
Morning, Your Honor. Raymond Cook for the People.
Good morning, Your Honor. Assistant Public Defender Nicholas Bukovitz for Mr. Sherbert, who is appearing via Zoom.
Yes, sir, can you state your name, please?
Evan Sherbert.
Thank you. All right.
I'm just requesting an adjournment for some time to finish some negotiations with the people, Your Honor.
All right. And how long are you going to be in the, what are you, Delta County?
Delta County, it looks like as of right now, it'll be till May 18th. But I'm hoping for earlier court date. They extended it out pretty far due to a different court case going on. But yeah, as of now.
You said May?
May 18th.
Okay, that's fine. It's March. Well, adjourn the matter to April 9th. See if we can get it resolved at that 2026 9 a.m. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case of the People versus Avion Johnson.
Andrew Childers, on behalf of the people.
Good morning, Your Honor. Edward Lucas on behalf of Avion Johnson.
Oh, there he is. Sir, can you state your name?
Avion Johnson. Good morning, Your Honor.
Morning. Thank you, sir.
Your Honor, we've been adjourning this a few different times. I think with one more adjournment, we have wrapped this up. I do communicate some additional offers to Mr. Johnson. I'd ask for 2 weeks.
2. They're gonna be able to get the writ out. Well, all right. Probable cause conference then March 26th. 2026, 9 a.m. Bound.
Thank you, Your Honor. Avion, I have an appointment set up with you tomorrow.
All right, thank you.
All right, next. Court calls cases, People versus Daniel Smith.
Yes, Your Honor.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Smith, who's in MDOC but present via Zoom. Mr. Smith, could you say your name for the court?
Daniel Scott Smith.
All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading guilty to 2 charges of use of a controlled substance, both 1-year offenses. Those being counts 3 and 4. Upon a successful plea to those charges, counts 1 and 2 would be dismissed. That is the court's full understanding of the agreements.
Yes, that's the full understanding, Your Honor. We are going to request this court to consider a same-day sentence, but it's not a part of the plea agreement.
Well, why would I be confused?
So he's been incarcerated since 2023. This is an offense from September 2023. He was arrested September 19th, so about a week and a half after 2023. He's been in prison ever since. And he's done a lot in prison. He's done advanced substance use treatment classes.
And it declined to do that.
Understood.
All right. So Smith, can you raise your right hand to be sworn? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. State your name for the record.
Daniel Scott Smith.
Sir, it is this court's understanding that you're going to be pleading guilty to 2 charges of use of a controlled substance. Those are misdemeanors punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
To the charge of use of a controlled substance as contained in count 3, how do you plead?
Guilty.
To that same charge as contained in count 4, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind? Yes. All right. You signed or had cause to be signed on your behalf an advice of rights form?
Yes, Your Honor.
You have any question regarding those rights?
No, I do not, Your Honor.
You understand that you're waiving or giving up those rights, including the rights that are contained in paragraph 5, those being your trial rights?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, not currently.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
Right. And also because you believe that you are indeed guilty of these offenses?
Yes, Your Honor.
Okay. On the date of September 9th, 2023, location of Gregory Road, Webster Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes, I did.
Did you also have fentanyl in your possession?
Yes, I did.
Did you use both of those drugs?
Yes, I did.
All right. And you knew that you were using cocaine?
Yes.
And you knew that you were using fentanyl?
Yes.
All right. So I do have to advise you that if you commit misconduct between the time of my acceptance of your pleas and the time of sentencing, that misconduct is defined in the Michigan court rules. You would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
So you're aware of any other promises, threats, or other inducements which led to this plea?
No. Yes, Your Honor.
No.
Well, you're not aware of any other promises, are you, sir?
No.
Okay. And have I complied with the court rule? Would it be proper to accept this defendant's pleas?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Precinct and report is 14A3. Probation sentencing will be April 6, 2023. 9 a.m. before Judge Fresh Hour. Bond will continue. Thank you, sir.
Thank you, Your Honor.
Court calls the case of the people versus Mamadou Diallo.
Morning, Your Honor, Raymond Cook for the people.
Ready Judge, Torsho Fisher, Assistant Public Defender on behalf of Mr. Diallo, who I believe is appearing by Zoom.
Oh, there he is. Mr. Diallo, are you there?
Yeah, I'm here.
Okay.
Thank you, Judge. Mr. Scott from our office tried to meet with Mr. Diallo, but was unable to meet with him. We are requesting an adjournment so we can meet with Mr. Diallo and go over his case.
Which girl prisons where? All right. Mr. Diallo,
Yes,
what state are you being held in?
I'm at FCI Cumberland in Maryland.
In Maryland?
Yeah, federal. Yeah.
And so you're trying to get through to him.
Yes, Judge.
Right.
Yes, Judge.
So let's do this. Sir, are you gonna be there in the month of April, you think?
Yeah, I'm not going nowhere.
Okay. All right. Then let me give you some time to try to get through to him. I'll adjourn this to April 9th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. All right. Thank you, Mr. Diallo.
All right, thank you too.
Court calls the case of the people versus Jessica Anglin.
Assistant Public Defender Nick Bukovich, appearing on behalf of Ms. Angren, who is now approaching. Can you please state your name for the record when you approach?
Jessica Nicole Anglin.
All right. I have 2 plea forms. Is that what we're doing?
That is correct, Your Honor.
All right. In the case ending in 5007, it's this court's understanding that she's going to be pleading guilty to an added count to abuse of methamphetamine, the 1-year offense. On a successful plea to that charge, count 1 would be dismissed. And actually in the other case ending in 5008, it's also pleading to that same charge with count 1 being dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Jessica Nicole Anglin.
Really? Strange no sense, but all right, ma'am, it's this court's understanding that you're going to be pleading guilty to 2 charges of use of methamphetamine, correct?
Yes, sir.
Those are misdemeanors punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes, sir.
Understand that while I'm taking the plea, I would not be your sentencing judge. And in the case ending in 5007, that you'd be sentenced before Judge Perry. And in the other case, you'd be sentenced before Judge Garwood. Do you understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
All right. To the charge of use of methamphetamine as contained in the case 5007 occurring in January of this year, how do you plead?
Oh, guilty.
To that same charge contains in case 5008 occurring in offense date on this in October of 2025. How do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir. Yes, sir.
Cause to be signed or did sign an advice of rights form, is that correct?
The form I talked about with you right there, asked me to sign it.
Yes.
Questions regarding any of those rights?
No.
Please look on the podium at paragraph 5. You'll see a copy of that. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes, sir.
Understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And because you believe that you are indeed guilty?
Yes, sir.
Starting in case 5058, 5007 on the date of January 14th, 2026 at the location of 449 Second Street, City of Ann Arbor, Washington County, State of Michigan. Did you have methamphetamine in your possession?
Yes.
It-
No, not really, but yes.
About to use it?
Yes.
All right. And you knew what you had was methamphetamine?
Yes.
On the date of October 6th, 2025, location of Wisteria Drive in the City of Ann Arbor, Washington County, State of Michigan. Did you have methamphetamine in your possession?
Yes.
Had you used it on that date?
No, sir.
All right, but you knew what you had in your possession was methamphetamine?
Yes. What time?
In looking at, now we'll look at the higher charges. The actual charge in this case and accepting your plea. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the judge would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
All right, and counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Satisfied.
The defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty in both of these cases. Count two. Count one is dismissed. Pre-sentence investigation and report is ordered, and in case 5007, sentencing will be
March 27th at 8:30.
March 27th, 2026, 8:30 before Judge Perry. And in the other matter,
March 31st at 9 a.m.
March 31st, 2026, 9 a.m. before Judge Garwood. And we'll continue. Thank you.
Thank you, Your Honor.
Copy that I put this in. Court calls the case, People versus Rita Olive. Is she in? He's in Zoom. Got it.
Morning, Your Honor. Ricky Cook for the people.
Ms. Olive, can you state who's their attorney?
Just rushing.
Ms. Russian.
Good morning, Your Honor.
Oh, okay, there she is. All right. Good morning, Ms. Russian.
Good morning, Judge.
Ms. Olive, can you state your name?
Ada Olive.
All right.
I apologize, Judge. I was waiting for her to walk to the podium. Sydney Russian appearing on behalf of Ms. Olive. I am sitting in for her attorney of record, Mr. Brandon Burnett, and that's with Ms. Olive's permission. Is that correct, Ms. Olive?
What did you say? I'm sorry.
Sydney Russian, remember me from last week?
Okay, yes.
And Your Honor, Mr. Byrd is remaining on one matter. I do note that there was a substitution sent in on one of the cases and it was adjourned. So we're asking to adjourn this matter to whatever date that PCC was sent to. I think it's gonna be put 2 weeks out.
Ms. Olive, it's another one for Ms. Olive, you mean?
Yes, she had 2 that were up for today. I believe that we are remaining on, let me get the exact correct one and I can make sure that the record's clear. I apologize.
Oh, it's okay. Mr. Cook, she has another.
Yes, Your Honor. So there's a substitution of attorney on the file ending in 0173. I've been informed by Ms. Olive's father today that they intend apparently on retaining that attorney on her remaining case also.
Got it.
That other one was adjourned to
March 26th, close.
Oh, okay. So it's probably 2 weeks out. My staff just informed me, believes it's March 26th.
that sounds correct.
All right. Probable cause conference in this case then will be adjourned to March 26, 2026, 9 a.m. Bond will continue. If for whatever reason we have those dates wrong, just contact my staff and we'll make sure that they match up. All right.
Thank you so much, Your Honor.
Thank you. Thank you, Ms. Olive.
Thank you.
Court call.
All right, everybody, we'll keep an eye on Judge Simpson's court, but let's go down to Florida. Wade Mercer.
There's 1 count of grand theft, 1 count of burglary of a structure, 1 count of criminal mischief. Ms. Toole, there is probable cause for these 3 charges. And Ms. Toole, my understanding is you're already on state probation, so listen to the attorneys and we'll see where we go from here. Mr. Mitchell, anything?
Your Honor, if a warrant hasn't been set in, we request a 7-day hold for probation to send one in.
Mr. McDaniel? Just reasonable bond, Your Honor. Thank you. So Ms. Toole, well, let me tell the attorneys this. So I received a warrant request on Ms. Toole. Today's Thursday. It must have been late Monday or late Tuesday after hours. I reviewed it. It was the same complaint, almost the same, but the warrant was for burglary of a dwelling. It said burglary. Obviously, it's better if the officer says burglary of a structure, burglary of a dwelling. It just says burglary. But when you looked at the statute number, it was the burglary of a dwelling statute, and it was a second-degree felony in the warrant. So I rejected it. And I said, it's either the complaint's wrong or the warrant's wrong. It can't be burglary of a structure and third-degree felony, at least not under these circumstances. So I rejected it. So rather than get the warrant amended, it appears the officer just made a probable cause arrest. That's what that's a guess on my part. So I went in this morning when I saw she had been arrested, and I just dismissed or rejected that warrant because there's no need for a warrant now because they made a PC arrest. So Ms. Toole, I'm just bringing everybody up to date on where we stand, ma'am, but there is probable cause for what you're charged with now. The reason that's important is burglary of a dwelling is a higher degree crime than burglary of a structure. You're accused of going in someone's shed and stealing some items. You're not accused of going in someone's home. What I'm gonna do is set you the following bonds. Ma'am, on the grand theft, because you're already on probation, your bond's gonna be $10,000. On the burglary of a structure, your bond's gonna be $10,000. On the criminal mischief, your bond's gonna be $5,000. Ms. Toole, your total bond is $25,000. Do not try to post it because I'm gonna do what I do 99% of the time, and that is I'm gonna hold you for 7 days. I wanna ask Mr. Mitchell to notify the state probation office of your arrest. It gives the state probation office 7 days to seek and obtain a warrant from the circuit judge on the VOP, and that Judge Garcia will decide if you're going to get a bond in the VOP. The vast majority of the time, if there's a VOP based on new felony charges, there's no bond. But if there's no warrant within 7 days, I'm going to release that hold and you'll be free to post a bond. If there is a warrant, we'll see if it's got a bond on it. So you've got a bond in your new cases. You do not have a bond in the 7-day VOSP hold. Do you have any questions?
Okay, they had me take a drug test this morning and I passed it. Is it just because I have new charges that they won't give me a bond or?
Correct. I did let the attorneys know that you passed your analysis this morning, and that is exactly right. The reason you're not getting a bond is because it appears you may have violated the terms of your probation by getting new charges.
Okay, and
Yeah.
also whenever I talked with because the investigators were going to my mom's house and asking about what was going on. And so, ma'am, sir?
We'll talk about your case.
Okay, but the investigator told me to mention it at first appearance. The investigator that I talked to told me to mention to y'all at first appearance that I was cooperative or whatever, and that I would do whatever I had to do to the guy, I forgot his name. I think it was Burgess or Isabella or something. And he said to mention it to y'all at first appearance.
Okay, and I appreciate that. That doesn't change what I'm gonna do today. Now, that may make a big difference. It may make a big difference later on. Okay, so don't talk about the case to anyone. But if you've been cooperative, that's something you need to tell your attorney that, and your attorney will talk to the state about that. And that is a factor the prosecutor and usually the judge also will want to know about. The other thing is you do have a condition. If you're ever on bond in this case, have no contact with that property. Don't go over to that property where you're being accused of this crime at, okay?
Okay.
Have a good day, Mr. Toole. We'll see you in 7 days. We also need to give her notice for her court date. That would be when?
It would be the 7th for both cases.
So Corporal, her court date would be April 7th at 8:30 on both cases. You're talking about both cases, you're talking about the VOP or?
Yeah,
just
the VOP would also be the 7th since the new law violation is a felony.
So we can't give her the VOP date until we get the. So just give her note for the 7th, please, Corporal. Then we'll do the VOP when we see her.
Yeah, posterity
So right
purposes.
now, for April, the VOP date matches the
No.
arraignment date?
That's just when it's a
felony in a. It goes on the felony arraignment date. It doesn't go on the VOP date.
Correct.
Because the VOP date for April is much later, right?
Correct.
Thank you.
For some reason.
We have Joshua Clenny next.
Mr. Clenny?
Mr. Clenny, good morning. Mr. Clenny, you're here for first appearance, accused of 4 charges. You're accused of possession of controlled substance without a prescription, resisting an officer without violence, possession of marijuana less than 20 grams, and possession of drug equipment, which is also possession of drug paraphernalia. Mr. McDaniel, do you want to be heard? We had a discussion about probable cause. Anything you want to put on the record? Nothing, Your Honor. So, Mr. Clenny, I'm going to find there's probable cause for these 4 charges, although I think that the possession of controlled substance is based upon what's called a residue amount. A residue means a small amount left in some type of paraphernalia or baggie or device for inhaling a substance. Sometimes the residue amount is not even enough to send to a lab. So typically the state attorney's office will make a decision on whether they're going to try to prosecute that or not. So I'm going to consider that allegation when I set your bond, that that one felony charge you have may end up going away. I don't know. That's not going to be my call. That'll be the state's call. We'll see what they decide to do with it. But right now you're accused of 1 felony and 3 misdemeanors. Let me listen to the attorneys and I'll set you a bond. I think you're entitled to one as far as I can tell. Mr. Mitchell, anything?
Regardless, Your Honor, we just request he be subject to random UAs.
Thank you, Mr. McDaniel. Nothing, Your Honor. Mr. Clancy, I'm going to set your bond at $2,500 each. I'm going to treat that felony charge as a misdemeanor because it does appear to be based on a residue amount. Your bond is 2,500 times 4. That's $10,000 cash or surety. Cash or surety means you can go through a bondsman. If you want to go through a bondsman, you have the right to do that. You'll get to use the phone in a few minutes, sir, to try to post the bond. You do have a condition of random urinalysis because you're charged with a drug offense. And Mr. Clenny, I'm going to ask the jail to give you a notice for your court date. We're going to give you a notice for your felony date right now because right now it's a felony. If it becomes a misdemeanor, that will change your court date. But right now his court date will be when? April 7th at 8:30. Mr. Clenny, do you have any questions?
No, sir.
Mr. Clenny, wish you the best, sir.
Thank you.
Yes, sir. Next, we have Foy Clenny. Mr. Clenny, Mr. Foy Clenny, good morning, sir. You're here because you've been accused of 1 count of possession of firearm by or ammunition by a convicted felon. That's a second-degree felony. 1 count of engaging in criminal offense with a weapon, which I'll come back to in just a second. 1 count of possession of controlled substance without a prescription. That's also a residue or residual amount. It's not it appears to be a small amount in some type of baggie or smoking device, and possession of drug equipment, which is paraphernalia. Mr. Clenny, I believe Mr. McDaniel wants to be heard on probable cause on the engaging in criminal offense with a weapon. Mr. McDaniel, is that correct? Yes, right. Just that it's not, I mean, it was found under a pillow. It was clearly he didn't have it in his possession while he was committing some felony, active felony. Mr. Mitchell?
Your Honor, I think from what we discussed, this may technically qualify as a carrying possibly. Given
The statute requires carrying.
Yeah.
The question is, allegedly, it was under his pillow, not on his person. So that's the issue. Anything, Mr. Mitchell?
We'll let the court decide on that, but regardless, we also request he be subject to random UAs.
So, Mr. Clenny, I want to find no probable cause on engaging in criminal offense with a weapon. That statute says you've got to use, display, threaten to use, or carry a weapon. There's no allegation you did any of those things. There's an allegation you possessed a weapon by constructive possession. This is not a constructive possession statute that you're accused of. So on that charge and that charge only, I'm going to find no probable cause. Officer certainly has the right to amend that within 24 hours if he or she wishes to. Regarding the other 3 charges, there is probable cause. I'm going to set you the following bond. The possession of firearm by a convicted felon is a second-degree felony, so the bond in that case will be $25,000. The other 2 bonds will be $2,500 each for the same rationale I expressed in your son's case. So you've got a total bond of $30,000 and no probable cause in 1 charge. You've got a condition of random urinalysis, Mr. Clenny. That means you can be drug tested at any time. I'm going to ask the jail to give you a notice for your court date, which will be April 7th at 8:30, and you will get to use the phone, sir, in just a few minutes. Do you have any questions?
No, sir.
All right, sir. Wish you the best. We have Amanda Hamlin next. Ms. Hamlin, good morning, ma'am. First thing I need to do is get your name correct because the complaint uses 2 names interchangeably. What is your last name, Ms. Hamlin?
My last name on my license is still Hamlin.
Okay. The complaint says Hamlin in places, and in some places it says Hamlin/Tucker or Tucker. So, Ms. Hamlin, you're here because you've been accused of 1 count of possession of drug paraphernalia. Ms. Hamlin, I'm going to appoint the public defender's officer to represent you, and I'm going to ask that you listen to Mr. McDaniel on this misdemeanor allegation.
Okay.
Your Honor, I spoke with Ms. Hamlin. She's going to plead no contest to charges listed. Understanding she'll be sentenced to 30 days in the county jail, $385 fine, 1 day jail credit, and she has signed a plea waiver form waiving right to jury trial and call witnesses. Thank you, Mr. McDaniel. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Hamlin, did you hear that agreement?
Yes, sir.
Do you have any questions about that agreement?
No, sir.
Ma'am, is that the plea you would like to enter to resolve this misdemeanor case?
Yes.
Ms. Hamlin, I'm going to accept your plea of no contest to the charge of possession, drug paraphernalia. Judge, you go to that offense, sentence you to 30 days in jail is the agreed upon sentence. 1 day credit, $385 court costs and fines are imposed. That'll be a civil judgment. If you don't get it worked off at the jail, hopefully you'll get it worked off at the jail. Ms. Hamlin, there's no probation involved in this sentence. You have 29 days left at most. The reason I say at most is hopefully you're going to get some game time and get out of there a little earlier with no probation. Ms. Hamlin, do you have any questions?
No, sir.
All right, ma'am, wish you the best.
Thank you.
Thank you. Cole LeBee. Ms. LeBee, good morning. Ms. LeBee, you've been accused of violating the terms of your state probation, ma'am. I've got a copy of a warrant in front of me, and it's a no bond warrant. It's been signed by the circuit judge, ma'am. So what I'm going to do this morning is I want to get you arraigned. I want to get you a lawyer appointed to represent you if you're asking for one. Ma'am, do you want to have an attorney appointed to represent you?
Yes, sir.
Ms. LeBee, listen to Mr. McDaniel. I'm appointing that public defender's office to represent you. No, we're going to plead not guilty. Yes, set this on the April 23rd court docket, and I advise her there'll be an attorney that'll speak with her prior to that hearing. Mr. Mitchell, anything?
No, Your Honor.
Thank you both. So Ms. LeBee, the public defender's office will speak to you before your court date, ma'am, and then you'll see Judge Garcia on that date. Do you have any questions?
No, sir.
Have a good day, ma'am.
Yes, sir.
Thank you. Andra Bell.
Andre.
Yeah, this is. Mr. Bell, I apologize. I said Andra because that's what the jail sheet says, but you told us at the last court date it should be Andre. Mr. Bell, you have a hold from the Florida Commission on Offender Review that used to be called the Florida Parole Commission. I think we told you this may happen when I saw you the first time. They have filed a detainer on you. So you've got a bond in your local charges. You have no bond in this hold from the Florida Commission on Offender Review, and they will be in contact with you at the jail if they haven't done so already. They have certain timelines they have to follow within their system. Just be aware, you've got some charges with a bond. You have another charge with no bond as of right now. Any questions, Mr. Bell?
Are you charged with no bond? You talking about the violation?
Yes. Yes, sir.
Okay, okay,
All right. Wish you the best, sir.
all right.
Now, I think we probably already gave him a court date in the felony. Is that right, Corporal?
Yes, sir, we did.
Perfect.
So can they give me a bond on this?
Yeah, but it should be out here. Next little bit of talk to you. I don't know where to stand, but they'll be in contact with us.
Is it, I think, I'm not sure. It's been a while. I used to represent individuals in those situations. I think it may be 10 days from the time the hold is placed on them that they have to, the parole commissioner or they don't call them parole commissioners anymore. That person, what do you call it? That person has to meet with them at the jail. I think it's 10 days from when the hold is placed, but I'm not sure. I'm not sure. I mean, generally, we don't ever see them or. Yeah. Mike, Mr. Campbell, how long do they normally take to come see them? I've seen them, it takes some months sometimes to come see them. So I don't know.
To be honest with you, I don't know.
Yeah.
They've been being pretty fast, but I don't know what time frame it is.
So thank you. Corporal, that's everything I had on my list. Anything else from the jail this morning?
No, sir.
Mr. Mitchell, anything from the state?
Your Honor, I just noticed and I was looking back, do we need to bring Michael Eubanks up to address the failure to appear that he had in his felony case?
No, he's got a court date. I think he's already been seen on that and he's got no bond on that.
Okay.
Yes,
He's
sir.
already been seen, correct?
Okay, I didn't know that. So no.
Once y'all make a charging decision on that, on the new cases, we'll either see them on a docket or if y'all ask for a warrant, we'll see it that route, but.
I got you.
All right.
Nothing else.
Nothing else. Mr. McDaniel, anything else? Nothing else, Your Honor. All right. So ladies and gentlemen, that concludes our docket for today. It's 8:40.
Okie dokie, friends. I will keep an eye on the state of Florida, see if anything else pops up there. In the meantime, let's go back to Michigan. Judge DeSanto.
All right. Thank you for addressing very appropriately for court. The court does have before it today the sentencing for your client on his plea to the property, $200 to $1,000. Amended charge of larceny. P 1,000 to 20,000, as well as larceny 1,000 to 20,000. The R and O and the larceny less than 200 were all dismissed by way of resolution between council. And council, did you have an opportunity to review the report and recommendation with your client? All right. Are there any corrections that need to be made? All right. And then as to the recommendation.
Your Honor, we are asking to be sentenced under HIDA per the recommendation of the probation officer. Mateo has a few words to say to you, but just, may I just accord on, can I give you a little bit of background?
Of course.
Okay, we have made restitution, full restitution on the counts 1 and 2. Mateo is gonna be turning 23 in May. He graduated from St. Mary's Catholic Central. He earned his associate's degree from Henry Ford College. He has a CDL license. He works full-time for Corrigan Looping Systems in Ann Arbor. His employer is aware of the situation and is very, very supportive of Mateo. His mom is in the courtroom. His dad was in the courtroom on prior proceedings. Parents are loving but firm. And all of the restitution, the attorney's fees, the court costs, everything is being paid for from Mateo's savings account. He had been saving his money to move out of his parents' house. Now he won't be able to move out because all that money is being spent on this criminal case. And I can just tell you, Your Honor, when I met him in jail in November, he was filled with shame and remorse and embarrassment. This is not something that is consistent with Mateo's character. And so with that, I'll have him say a few words to Your Honor.
Okay, thank you.
I just firstly like to apologize to the court system for wasting their time and energy, to the victim for causing damage and property, stealing their property, for embarrassing my family, to the police officers that night that I ran from, for making them deal with the actions of me and my co-defendant. I deeply regret my actions. It is not my character to steal or damage or run from law enforcement. Being intoxicated is not an excuse for running, causing damage or harm, or running from the law. I'm in the process of learning from my mistakes and becoming a better person, so that this may never happen again.
Okay, I appreciate those words, sir. And just so you're aware, when someone's here in front of the court, it's not a waste of time. We're here, right? We're here for whatever we have to be here for. And if you have learned from this experience so that you're not going to repeat these behaviors again, then it's 100% not a waste of time. Okay? And I appreciate your words, sir. You may not be aware of how many individuals are present for sentencing that have victims in there and choose not to say anything, which, quite honestly, is a bit concerning for the court, because then the court doesn't know if they are actually remorseful or not. So let me just clarify one thing. Yes, the restitution was paid to, I believe it was Mr. Henderson and Miss Williams. And I say this because last Thursday, the co-defendant, Mr. Quitter, was sentenced. In that matter, Miss Moak, I believe, M-O-A-K, she was one of the main victims. But she had sent in an email indicating that she was requesting restitution, but I don't recall that she had a specific. So when you indicate, counsel, that restitution is paid in full, the restitution that was known at that time with Mr. Henderson and Miss Williams, that has been paid in full. The representation of Mr. Mohammed with the prosecutor's office was that the information they had was that there was no other restitution that was being requested at that time. It wasn't until the communication came from my probation department to the victims per the Crime Victim Rights Act that we were made aware that there was a third victim that was requesting restitution. So I only say that to say that, yes, the restitution that was known at that time for Mr. Henderson and Miss Williams were paid for in full. However, there may be additional restitution. Now, that would be jointly and severally. and with Mr. Quitter, as I indicated to Mr. Quitter, and that would be done after a restitution hearing. Because we don't, unless there's an amount that's been agreed upon, right? Because we don't know what that amount is, and we don't have that information yet. So I just wanted that to be stated for the record.
Specified, Mateo has responsibility and however it plays out, we'll be fine with him.
Okay, and so Mr. Hills, again, I do appreciate that you did apologize to the individuals while you're here in court. Because Mr. Henderson was simply working another job so that he could get Christmas presents for his kids. And so then it ended up being the additional cost and expense of that. So with all that being said, the court does find that there's reasonable grounds to depart from MCL 769.5 based upon what the court has heard from Mr. Hills and from Ms. Prasad, as well as reviewing the report and the recommendation. The court also finds that the following sentence is in the best interest of justice, is reasonable proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Hills and the legislative guidelines. The court's going to order 24 months probation. You are eligible for early discharge, and I'll go over that shortly. You are also eligible under HIDA. You are not to violate any criminal law of any unit of government. You are not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, whether in person, in writing, or virtually. You are to notify probation immediately of any change in address or employment status. You are not to use any alcohol or drugs unless prescribed, and you have to participate in random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. And sir, it does appear for both you and Mr. Quitter that alcohol played a significant role in the behaviors. The court's going to order that you are to enroll and participate in outpatient substance use counseling. I understand that you currently are, so you will continue with what you're currently doing. I'm not going to indicate you're to find a different one. You can continue with what you're doing. The rehabilitative goal for that condition obviously is so you can have continued assistance in providing coping mechanisms so you can hopefully prevent this matter from happening again. You are not to have any contact with any of the victims. The only other individual that we're aware of, as I've indicated, was Ms. Moak. And then that would be set for a restitution hearing to determine the amount if that's what is put forth. I'm just stating that, sir, so you don't think that we're just going to take a statement that says, oh, I'm out thousands of dollars and just say, okay, this is what you have to pay. There has to be some supporting documentation for that. Okay, just as there was for the other two individuals. And then you have to participate in the making decisions class. The rehabilitative goal for that condition, sir, is so that you can further understand consequences of poor decision-making, hopefully preventing this from happening again. Okay, do you have any questions regarding those conditions?
I do not.
Okay. The court's going to, I don't remember what I said for, I'm sorry, can you please pull up Mr. Quitter's case? Yes. Yes. Can you please tell me what I assessed for his fine on the MDOP? 200 to 1,000. Yes. I'm sorry?
2,825.
Oh, that was the total. Okay, so I'll work backwards. What I'm trying to do, counsel, I'm just trying to make sure that they're it's the same here. Okay, and then for count 2, the larceny.
There's 1,325.
And then count 3, the RNO attempt. 825. Okay. So it's going to take me a minute here. I'm just going to work backwards, counsel. I can tell you that the screening fee was $100. The oversight fee is $1,200. Crime victim assessment fee of $75, justice system assessment fee of $50. Cost of prosecution, $300. So, what do we see there? That didn't include the restitution amount though, did it? I don't think so, because that was already paid. I'm missing something in there.
You want the total or no?
Well, what does it show that the fine, just the fine was assessed?
For
For count one?
fine, 1,000 then? Would that be right? And that's state cost of the 50 and miscellaneous 75.
Yes, let me see here. And did I assess $300 for cost of prosecution or $400?
I don't see that.
Okay,
I'm not sure.
okay. And what does it show? Let me see here. So.
Wait, what are the fines I can do?
If you go to the fines, okay, where does that show?
And I have this 1,000, PBO is 1,200. You know, the crime victim was 75. The SCRG probation court was 100, miscellaneous was 400, and the
Oh.
state cost was 50.
Okay, so that's where my difference was here. Okay. All right, where does it show the fine is for count two?
It's 1,325 says total due. So broken up cost was 100, miscellaneous 275.
Wait a second, what's
And
that?
then 1,000 for the cost,
Oh, 1,000, okay, okay,
the state cost 50. And then miscellaneous was 275.
all right, and then I'm going, let me see here, 75. And then do I do 400 for count three? Or 500? Okay, miscellaneous was 200?
275.
Okay, well, it's 200, then the crime victim was 75, I think, but okay. All right, perfect, thank you. All right, so, all right, so council, I just wanted to make sure I was keeping that balance between the two. So, the court's going to order under count one, $1,000 fine, $100 screening assessment fee, $1,200 supervision oversight fee, that's $50 a month at 24 months. Since you're eligible for early discharge, up to half of that could be waived. $400 for the cost of prosecution and crime victim assessment fee of $75, justice system assessment fee of $50 for total of $2,825. As to count two, that is a $1,000 fine, $200 for the cost of prosecution. I didn't charge a screening or an oversight fee because I just charged that on count one. $75 crime victim assessment fee, $50 justice system assessment fee for a total of $1,325. And then the last count of attempt R&O is $500 fine, $200 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. For a total of $4,975 between all three cases, sir. Keeping in mind that up to $600 of that could be waived if you discharge early, okay? So I know that's a large amount, sir. and you'll be stuck living at home for a little bit longer. But I'm gonna have you set up your payment plan with probation, okay? And, as I did indicate, you're eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. Okay, any questions? All right, good luck to you.
Thank you, Judge.
Thank you. Good luck to you, sir. Have a seat over in probation. Somebody will be with you shortly.
Thank you.
Thank you.
It's a Thursday morning here at TCF Live. Good to have you all with us. Hope you're enjoying your day so far. Let's go down to Ohio. Judge O'Donnell.
With sentencing. Thank you.
Thank you. Is that what you want to do?
Yes, sir.
What's your plea to the allegations?
I'm guilty of everything that was said.
Ms. Tomaszek?
Yes, thank you, Your Honor. We would just like to ask the court today for any leniency in sentencing. And speaking with Mr. Madoc, I understand that these cases are much older. He understands that as well. Your Honor, he does suffer from drug use and mental health use. Per Mr. Madoc, he has been diagnosed with bipolar. At the time of failing to appear for probation, he indicated he was having issues with his bipolar medication. He was reaching out to Signature Health to try to get adjustments in that medication, and unfortunately was unsuccessful, so he did take himself off the medication. So we'd just like to ask for any leniency in sentencing today. Thank you.
Maytech, what do you want to tell me?
Do I have a second, Judge O'Donnell?
Sure.
So last time I wrote you a 15-page letter and completely annoyed the crap out of you, and
How do you know you annoyed the crap out of me?
because it was mostly bullshit, and you could see right through it, and you're a smart man, and I know you could, and that's why we are here again. I lost my father a couple months ago. He was killed by a nursing home. I am on my own. I have my own place. I still work for Jack, the guy that that I got this case from. I work every day. I have my own apartment in Cleveland. Me and my girlfriend. I've actually been doing really good. I was trying to save money. I'm getting money from a lawsuit from my dad I was going to come back to court and pay it, but that's neither here nor there. I don't want to waste your time anymore, this court's time, and keep dragging this on. This is 10 years old. I haven't been in trouble since. I haven't hurt anybody. I haven't stolen anything. There's not one thing I've done to the public to prove that I'm a nuisance, that I don't belong in the public. I mean, I've been on and off bipolar medication. Some's worked, some hasn't, and it's been a nightmare for me. But the real thing is I go to work every day, sir. I don't cause anybody any trouble. I haven't, obviously in 10 years, I haven't got a new, charge of stealing or theft or anything. And that's the honest to God's truth.
If you got that mental health condition, why don't you do something? Why don't you do something about it?
Well, because I've been too scared, because I haven't had an ID. I've had warrants, so I thought that they would arrest me if I go to any place like that.
But how do you think using meth helps your mental health condition?
It helps it's helped my ADHD. I use it in the morning one time. I take it, I eat a little piece that I have. I don't sit there and snort the stuff all day. I don't sit there and go wild and get high. It has nothing to do with that. I use it in a waste.
Well, see, I don't know that, right?
No, you don't.
I can't possibly know that.
And I can't prove that.
Right.
I do know one thing. I don't honestly think I deserve to be, I think letting me go today would be honestly the fairest thing, because I know you don't usually do that, but I haven't hurt nobody.
I never do that. Because that's, you see,
sir, it would,
look at,
I'm sorry.
boy, oh boy. The prosecutor on your 17 case and the public defender both retired a number of years ago. That's how old this thing is.
Yeah.
Okay. So you had a being and entering and a receiving on the 17 case.
Yeah, Jack was supposed to come here and actually tell you guys that those items were found, but that's neither here nor there. It doesn't matter today.
And you were given intervention on that case, which meant if you complied with the 2-year plan by August of 19, you would have had that record erased.
I wish I
So-
would have done that.
I wish you would have done it too.
I've always wanted to be a cop. That's been my whole thing, my whole life, honestly. But
So, so we tried a bunch of treatment, you disappeared, and you kept disappearing. And you get this other charge, which is a failure to appear, because you kept disappearing, and then you disappeared some more.
it was due to my hip replacements and everything that happened.
But that was all going on last time you were here,
Yeah,
okay? And we addressed that as best we could, and then, you know, I addressed the mental health stuff when you were here back in November of 23.
and I did go, I was meeting with them, and then it just started giving me really bad nightmares, and things were just,
Okay, well, that's why you need to address it, not just stop taking it and not show up. I mean, that's your biggest,
I do want to work with somewhere, honestly. I really do want to work with a facility, and now that, once I get out, that I don't have warrants and stuff, I'm able to go to a hospital and get an ID and actually go and do these things, and that's huge to me. That's part of why I'm coming here and I'm saying, let's get this done, because I want an ID again. I don't want to have to hide. I don't want to have to run. I want to be able to keep my apartment, keep my life, and be able to go to and get a clinic and get, I'm not here to cause anybody trouble. I'm not here to hurt anybody out in the public. I just want to work and make a life like my father and everybody else.
you wasted a good, 9 years.
More than that, sir.
Well, I know that, at least in the 9 years you've been coming here. I mean, that's completely wasted time.
I've been grieving my sister since then, and it's half my life has been wasted. I don't want to waste it no more. This is a chance for me to get my ID, and I can actually go and get help in the things that I need. And I wish there was a way I could prove that to you, not that you care, or you know, honestly,
Well,
but just,
listen,
yeah. I just want to show you that, you know, you haven't wasted your time, that I can be a member of society, that I'm not going to screw up anymore.
but that's completely on you.
I just don't have a dad to turn to. I have no family. They were all just, you know, killed. You're somebody that I look up to, and I'd love to show you what I have built, rather than, you know, I'm just a screw up and nothing. I mean, not having my dad here right now is hard enough for me. Honestly, I'm actually in the process of burying him right now. He hasn't even been buried yet. That's part of the main reason why I really, you know how close I was to my father and my family, and that's the main reason I'm asking for this to be dismissed and let go, so I could be with him, and bury him. He was killed by the nursing home in Euclid, and I just want to be able to bury my dad and get help and do these things, and I have my own place. I'm not going out into, me and my girlfriend both live there. I work for Jack. I'm still in the same, none of that's changed.
Do you still live up off of St. Clair?
No, sir, my address is 4172 Rocky River Drive, Cleveland, Ohio, 44117, or no, I'm sorry.
Did you used to live up by St. Clair, or did you work there?
St. Clair.
Around 185th up there?
Oh, that's my boss does, Jack James. He doesn't live there though anymore. He's in Charlotte. But there would be nothing better in this entire world to me right now to be able to go bury my father and get help and get an ID and be done with this. You know.
So what has stopped you in the past from doing that? Say in the past 2 years, what stopped you from doing that?
me getting an ID and not, and having to hide and run, and I've just been working
Well, you were hiding, why?
because I was scared of this day.
Okay. Yet, here you are.
I never thought these things would come about like this. I never thought my dad would be killed. I don't want to be in prison and it goes
When did your dad die?
a couple months ago.
And how old was he at that time?
76, sir.
Well, you certainly knew that that time was coming sometime, right? I mean, everybody dies,
Yeah, he was in really good health though. He choked to
Right.
death.
but then that happens. Okay, so the question is, what do you do? Where do you go from there?
Well, I have there's a lawsuit against the nursing home, but I just
But regardless of the lawsuit,
Okay.
the lawsuit either works or it doesn't work, okay?
showing him that I can do the right thing.
But whether it results in some vindication for you because of what happened, it may or it may not. But whatever way it goes, you still gotta move on. I mean,
And that's why I'm not ruining my life.
If it doesn't work out, then what are you gonna do? You're gonna go into like a meth depression or what? I mean,
No, that's
yeah.
what I did with my sister. I ruined my life when my sister passed away. I screwed up. When she got killed, I did a lot of dumb things, but if I have an ID right now, I'm going to get medication, not meth. I can promise you that. I could care less.
Where? Medication for what?
I'm going right back to Signature Health.
Okay.
If I got out of here today, right now, if you said we're done with this, instead of going home right now, my first place is going to Signature Health to get signed back up so I can get medication.
You gotta understand something, sitting here, that this isn't, this, if you were on probation in Cuyahoga County, I guarantee you that they would terminate your probation right now and you'd walk out the door and go on with your life without having any probation, okay? That's a certainty.
I would rather be back on probation, honestly.
But I don't do that, because then what have you accomplished, what has the system accomplished by rewarding you for consistently not showing up? Because nothing has been solved, okay? You still have the mental health condition that is untreated, and now you're on top of that, you're piling the meth. And I can't imagine a worse combination than not being treated for bipolar and using meth. I mean, you'd be
right.
like Ricochet Rabbit bouncing off every wall.
I don't. I go to work every single day,
Yeah,
sir.
that's okay,
I deal with it.
except I know none of this,
Jack's told you before, though.
okay? I haven't seen you in 2 years.
Yeah, that's true. That's true.
So,
Sir, I would go right now today, right to Signature Health, not to get meth, and I would get the medication that I need. And I'm not just saying this to get out of jail. I'm saying this because I want a life. I want to be able to bury my dad. Burying my dad right now is the only thing I want to be able to do.
if you want a life, then it's up to you to create the life, regardless of what I do.
Yeah.
Right? I mean, right now, you got 2 F5s and an F4. Okay? So right now, I could give you 42 months with credit for, what, 9 months, 10 months, something like that? And you have then 32 months to do. Okay? And then at some point, you get out, and you determine what you're gonna do with your life. Doesn't matter what. See, nothing I've done in 9 years has mattered. Okay, I've had no effect on your daily life, because you've done whatever you want to do. Okay, you end up in Kentucky and wherever. Okay, that's the only place I can say for sure that you've gone, because that's where they grabbed you, and that was a nightmare, right? Okay.
It was
So,
hell. It was
now,
all hell.
when you were here, after you pled guilty on this failure to appear, and I sentenced you, you talked about in that pre-sentence report what a nightmare it was, and how you would never do that again, and you're gonna comply with everything, because you don't wanna be put in that position again.
I just wanted out of jail every time, and I wanted to not be on probation and do, I just wanted, sir, I know one thing, if there's anything else going on right now, I don't wanna lose my place. I've worked hard to get it, and that means more to me than any drug or anything else. And I don't wanna lose not being able to bury my father. I mean, I have to
Okay,
make,
then what beyond that?
I want to be sober and not do anything. That's like a huge thing to me. And I can't, I don't need anything. I've just been so messed up with all this court and warrant stuff.
What was, remind me, because it's been so long.
Yeah,
You had a breaking and entering and a receiving on that 17 case.
yes.
What were the facts of that?
It was the weed whacker, it was my boss's weed whackers. He didn't pay me for plowing for 4 months, and I needed cigarettes.
So you got into his wherever he stored the stuff and took it?
I was, yes. Long story short, supposedly I took the 2 weed whackers, and
Supposedly.
I sold one of them after he didn't pay me for 4 months, and that's where we started at.
And what involvement did drugs have in that?
None. That had nothing to do with drugs.
Okay.
That was me not getting paid for plowing. Because I plowed for him for 4 months straight, and he didn't pay me once during that time. If you could once go against everything that you probably would normally do and let me.
I ask her what I normally do. There is no normal here.
Oh.
This is completely abnormal, this place.
No, I know it's a zoo here,
Okay?
but
So,
I mean, if you could let me bury my dad.
so
And
you're right about one thing, okay? That you apparently haven't committed any crimes anywhere else, because sure as shit, if you did, you'd get caught.
I'm not the smartest criminal, I guess you could say, sir. I haven't, and I'm not a threat in any way to society.
You're a pain in the ass to society, okay?
No, just to you, sir. I'm not sure that. I would never steal from somebody again. I learned my lesson on that out of anything that happened. I learned I would never touch another thing in my entire life. I wouldn't take a pick, after dealing with all that, I wouldn't take a pack of gum. That did teach me a lesson on that part. I would never just steal. I'm not a threat to any public at all. In any sort of way.
When did you get arrested on this thing?
A couple of weeks ago,
And how did that happen?
I was driving my dad's vehicle to one place to another. I was moving some furniture into my place. Some more furniture. Without a license, like an idiot.
Didn't I tell you to get a license? No?
I couldn't go without having warrants.
Why don't you have a license?
Because the warrants thing,
What else? What other reasons don't you have a license?
there would be no other reason right now. If I had no warrants, I'd go right and be able to get my license.
Well, the warrant's not stopping you from getting a license, right?
Yeah, because they'll arrest me on site if I go to try to get a ID. That is literally the only thing. I will have my license in days if I was able to go home.
When's the last time you had a valid license?
10 years ago? You know, the original crime that I committed here and the original thing is stealing. And I learned my lesson on that. I absolutely 100% learned what is not right. I'm not causing, I'm no, as you can see, I'm no harm to public, man. And sir, I don't mean to say man, I'm no harm to public. I just want to go about my life and live it the right way. And I know how to do that. It's just this whole court thing and being tied, it's twisted my head backwards. I finally got my own place. I just want to bury my father and go about that. And you'll never see me again in this court. I mean, you'll never see me in
Those are the famous words.
You'll never see me in Lake County again, that's for sure.
Well, shit, you were right about that because I hadn't seen you for 2 years, right, in Lake County.
I learned where to stay away from, sir.
I know, you stayed away from here, you stayed away from the probation department.
I was scared shitless of any of them.
Okay.
This stuff has scared me to the death of me. I don't belong in prison. I'm not a person that should go. I don't. I just don't want to lose my place and everything I have worked for because I don't have anybody to rely on now or jump back on. I don't have my dad. I don't have my mom. My sister's dead. I don't have anybody. It's just me. And this will wreck everything that I have tried, and this will put me in a bad spot then. And
Well, of course it will. Prison puts everybody in a bad spot. Some people get out of that bad spot, some people don't. But believe me, anybody who I send to prison here, or you can believe her, or you can believe her, certainly has earned those prison stripes, okay?
yeah, I
Because
understand.
I don't send people there lightly.
I understand.
All right, I'm gonna continue your community control. 10 days in jail. How many does he have on this? Is it 7?
He has
Oh my God.
5 days. He's arrested on 3/8.
Okay. With credit for 5. You're gonna go to Signature and get involved in the dual diagnosis program. You're gonna follow the recommendations.
Can I hug you? I'm
Huh?
serious, sir. Could I
No.
hug you or give you a handshake, something?
No hugs, no.
But
no,
I know
just-
I'm sorry.
Just here's what you can do, okay? You can show up at Signature, you can show up at probation and get your shit together, okay? That's the equivalent.
I never deserved this from you. After all the shit I've put you through, and I've heard a
So-
lot worse about you from other people, and
I
it's
don't
not
care
true.
about that. People, you believe that, Kim? People say bad things about me?
Not bad things about you that you don't fuck around, excuse my language, that you don't mess around.
All right, so I told you last time you were here, the terms of only one doctor, only one dentist, and one pharmacy. Take the medication as prescribed, sign your releases, full employment, GED, 2 AAs a week and a sponsor, and a valid license. Now, what I was gonna do with you was I was gonna send you for 14 months with credit for about 2 months, okay? But keep in mind that what's available, because you've burned me twice, right?
Yeah.
Okay. Not burned me, I don't really.
I
You've burned
understand.
yourself twice, okay? So there's 42 months out there if you burn yourself a third time. Because remember, if you decide you're not gonna show up, you're gonna get caught, because you always do.
Every time.
Okay? And I tell you, one person who's gonna be really pissed about this is Jennifer,
Oh, I know, she don't wanna see me.
okay? All right, Kim, anything else?
No, Your Honor.
Ms. Tomasic, anything else?
No, Your Honor, thank you.
All right,
I don't know why you've been so helpful and lenient towards me, and I know you shouldn't, but I do appreciate it, and I think I'm gonna try, I'm not gonna tell you I'm gonna do it, but I'm gonna try my absolute hardest
why don't you,
to not see you again.
don't talk about it, just do it.
Judge O'Donnell?
Well, that was super interesting, friends. The one thing about O'Donnell's court is it's just an incredibly raw place with very, very plain language. But I don't know that I have ever heard a defendant who's being sentenced asked to hug the judge. That is a first, at least here on TCF. Okie dokie. Let's go back to Michigan and let's go back to Judge Oakley.
You guys don't have to jump up.
Your Honor, in this case, just briefly, my client was stopped, going down Will Carl. The police came upon him because of 2 911 calls. One is suspicious because it came from my client's own phone, from a distance away from someone else's house. The second one is a valid 911 call. It's credible because the caller gave his version last name. Said saw someone walk down the road, looked intoxicated and stuff. Where they used to call. Neither of these calls put my client behind the wheel of the car. The first one says there's a car in a ditch and there's someone on one road and there's someone walked down another. The police come. They talk to Wallace, and he makes some statements that ends up getting charged with operating while intoxicated. He was never Mirandized, but even if he was, it doesn't really matter. The statement that Mr. Wallace made during his interrogation are inadmissible unless they're voluntarily, knowingly, and intelligently waived his right to self-incrimination. They must have been made with full awareness of both the nature and the right being abandoned and the consequences of the decision to abandon. The people quote Bergamo and Oregon as stating that the police don't have to Mirandize people on traffic stops. I understand that argument. I've made it myself before. The difference here is that the people completely ignore Cipriano and Stewart. And Cipriano, there's 11 factors looking at whether or not the statement was knowingly made. The age of the.
Well, that's 2 different issues though. First is, should they have Mirandized him? And your argument is Miranda or not, statements aren't usable. Yeah, so let's not mix those 2 arguments. Right, let's talk about first one first. Let's talk about whether or not they should Mirandize him. Unless you want to just skip that one.
I'll skip that one because I think Bergamo and Oregon control on traffic.
Okay.
Say this is a traffic stop. They were walking down the street. It's more akin to a Terry stop than a traffic stop. But even if he wasn't Mirandized, I think Cipriano and Stewart control that, because Cipriano looks at whether or not constitutional advice would render whether the person was Mirandized. It's one of the factors, and none of the 11 factors control in and of themselves. Cipriano looks at the totality of the circumstances, so they look at all of the factors together along with everything else. So whether or not he was Mirandized, I don't think is the issue here to allow you to suppress the statements.
All right, then let's talk about the other factors.
In Cipriano, the control are the age of the defendant, the extent of the prior police contact defendants had, lack of constitutional advice, injury, intoxication, or ill health of the defendant, and deprived of food, sleep, or medical assistance. My client Mr. Walsh was 22 days away from his 21st birthday on the date of the stop. Stewart was an 18-year-old. There's not a lot of difference between a 20-year-old and an 18-year-old, I believe. He was young. He didn't know because his development's in frame, not complete yet. He's not juvenile, but he's not an adult. Fully formed. He hasn't had any prior police contact. He's not aware of his rights completely. He wasn't Mirandized. He was highly intoxicated. And he was potentially in an accident. He did ask for medical care. He was taken to the hospital. The blood draw feedback is 0.25. It's exceedingly high. It's 3 times the legal limit to draw. I find it
difficult to believe that we could say you should be intoxicated, but yet we're gonna take every statement you say against your own self-interest as the main. When you add in, you take all of that and you add in the facts of the first 911 call, I included an affidavit from the client's lawyer. The people say they don't understand the reasoning for that. The reasoning for that is, Ms. Wallace, when retrieved Mr. Wallace's phone that day from this other individuals, Mr. Speed, who I believe made the phone call. I believe the phone call was made from that phone for two reasons. One, there's a screenshot of my client's phone saying it was used to call 911 at 11:40 on August 2nd. And two, when you listen to the 911 call, the individual who says his name is Brandon, is talking to the 911 saying that there's a car in a ditch. It's a 300 Chrysler, it's black, and there's someone walking down Will Carlton Road. While he's making that phone call, while he's making that 911 call, an automated message from Mr. Wallace's iPhone breaks in and says, the owner of this iPhone has been involved in a serious car accident. They're not responding, and they give GPS coordinates. And those GPS coordinates just happen to be Mr. Speed's house. So there was another person in the car. It's entirely possible that Mr. Spino was the driver, put the car on the ditch, and took off with my client's phone and made this phone call at a later time. That's reasonable doubt for a trial, I understand that. But when you look at that and you put it all together, there is reason to doubt my client's statement because of his level of intoxication, because someone else was there and was potentially driving, because no one saw my client driving. I believe these statements should be suppressed. I believe that they're not credible based. And without these statements, there's no one to put it. Mr. Wallace operating the vehicle.
Anything else at this time?
No, Your Honor.
Madam Prosecutor?
Statements such as I parked it there, I just stopped there and I figured I would just walk the rest of the way and get it towed. I ain't going to bullshit you. I am obviously way too intoxicated to drive, and that's why I stopped. Defense wants us to believe the defendant was still undergoing physiological and neurological maturation, was unable to fully understand or appreciate the situation and the statements that he had made. If we were to apply this standard, then all men in their late teens and early 20s would be given a pass to commit crime up until their prefrontal cortex is fully developed. Defendants made multiple decisions that day. He made a decision to drive drunk. He made a decision to make these statements. He made decisions such as electing not to complete field sobriety tests. He made decisions not to, when asked where he got the alcohol, he told police that he didn't want to tell them. He made decisions such as when they asked what friend's house he was heading to, he elected not to tell them. He made all of these decisions that day. I find it hard to believe that he can make all of these well-informed decisions if he wasn't able to fully understand those statements, such as I parked it there, I drove, all this other statements that he made as it relates to driving the vehicle, but can't appreciate the statements such as not getting consent to do field sobriety system or a PT or anything of that nature. He also told police that he knew his laws. He told police that he came from a background of law enforcement officers who was making very clearly informed decisions based upon the situation.
Respond.
Yes, Your Honor. One, I don't believe that you can take one instance, this case in particular, and paint everyone's getting a free pass for committing crimes because they're not over 25. That's not the point. My point is fully looking at his age. It's one instance. It's of the Cipriano, the 11 Cipriano factors that goes towards the entirety. So we're not saying that everyone gets a free pass because they're not fully formed yet. That's a broad generalization of people, not a form. Again, age being one factor, the level of intoxication being one factor. You could have said killed Kennedy, doesn't mean it's killed. So I think that everything needs to be looked at much more closely and not just cherry picked. Oh, he said he was drinking driving, so obviously it wasn't. When there's no other corroborating surface, no other corroborating evidence whatsoever. Not even the 2 911 calls put him in the vehicle. I saw a guy put his car in a ditch and I was walking down the little car. That would at least be some circumstantial evidence that he was operating the vehicle. People also raised the fact that the car was tied to his mother, that one of his credit cards was in the car, and that he had the key fob in his pocket. So, obviously he was driving. Having a key fob for a new model car doesn't mean that you're operating. It means you could be sitting in the passenger seat and someone could push the start button, the car starts. You could be next to the car and someone pushes the start button and it starts flipping, you're operating. Looking at everything, again, looking at the totality of the circumstances, including the suspicious 911 call. I believe causes a credibility issue with the statement of a 20-year-old who had a 0.25 BAC.
Anything else? Let's talk specifically about Cipriano and how it applies to these facts.
So let's see. So the age of the accused, the defendant was already shy of 20 years old. In my investigation, intelligence level, I understand now from the local police, he explained that he had a lucrative career as some sort of stunt murderer, content worker, what have you. He obviously knew, he told police that he understood that he could not drink. He understood that he should not drive when he was intoxicated. He had knowledge and wherewithal to know that these things were wrong. The extent of his previous experience with the police, I know that he had no priors, so I have no reason to believe that he knew, but he did know they were police, they were fully uniformed and what would identify themselves as police officers. Going to the detention of the accused, but according to the statements in question, he almost immediately stated that the car was illegal. He went on to say all the other statements just within the first couple of minutes of interaction with police. The lack of any advice to the accused of his constitutional rights. Again, he knew that he told the officer that he knew his laws, that he had police background or to his family. He made decisions such as not doing the PBT, not doing field sobriety.
How's all that fit Cipriano though? The fact that he made decisions, how's that fit Cipriano? I understand his statements that he knows law enforcement, he knows cops, whatever, I know my rights, whatever that is. I understand how that would fit to his educational level. But how does all this other stuff you're giving me fit Cipriano? Having made other decisions?
I mean, well, there was, lack of any advice to the accused of his constitutional rights. Because he knew that, he stated that he knew the laws.
Right.
Knowing the laws, he knows that he can say no to certain things, such as the PBT and those crimes.
Okay. Anything else you want to say about Cipriano?
I think those are the remaining factors if you wish.
If you think they help you.
I guess you can start where, whether the accused was injured, intoxicated, or drugged, and in ill health when he gave the statement. He did have a very, very, very common case. Was intoxicated, but frequently in the other case, people are intoxicated. That is probably 15% of traffic stops are drunk driving. In order to investigate drunk driving, you have to ask questions of the individual. He did tell the officer that he needed some sort of medical intervention about half an hour into the investigation. Officer McNally immediately called for assistance. Officer Didosecki was on scene. He is a trained and certified EMT. The defendant could not articulate what was wrong with him other than not feeling well. I think that would be the last one.
Okay. All right. Anything else?
Yes, you are. I understand that, voluntary injection of food altering substances, alcohol and drugs isn't a defense between harm. So we're not talking about whether the crime was committed here. We're talking about the statements that were made that would link my client to these charges. And again, I think it bears repeating, a 20-year-old with 0.25 alcohol beyond and underage drinking, everything else goes along with it. I think looking at taking that into consideration with these statements, who knows what he's saying is true, and there's no other corroborating evidence to put him behind the vehicle operating. All you have is these drunken statements with no other proof. With that, I believe statements can't be looked at as credible.
Anything else? Anything else?
No.
All right, it's a close call, counsel, but I'm going to deny your motion. I encourage you to appeal it. Anything else? Good luck. Why am I doing an arraignment on line?
Here, Judge Patton's over.
Is this one of them? This one that I got Ackman that Jamie handed me?
Must be, yeah.
Oh, okay.
Yeah, he got, it was the number that we could have, his file. Yeah.
I only have this one. Are we ready on Ackman?
Thank you.
Jamie, did I leave some?
Yes, sir.
Judge, Wayne County is not on Zoom yet.
Those are arraignments on?
No, no.
Is Ackman at Wayne County?
Yeah.
Yeah.
That's all I know.
Aaron Frazier. Figure out what's ready and when, and I'll be happy to do them. Good morning, counsel. How you been? Haven't seen you for a while. Good.
Okay, just,
Keeping busy?
sponges lately, so that's
Good.
lighter side of what we do.
Yeah, more fun, eh? Yeah. All right, so tell me about Mr. Frazier and his file.
So Mr. Frazier, he is,
If it is, I'll enter not guilty plea and we'll move forward.
He's 40 some college, with Rambus High School. He has the aunt and mother present in the courtroom in front row.
Beautiful.
And, Anthony Floyd has 5 children, from 12 to 17. No prior drunk driving cases, he had prior, suspended life. Coming from, he can see it, high and he's younger.
Okay.
So basically, he had this traffic and stop, and they said he had a high block. He was coming from his nephew's birthday party. They've given us some offer. Disobeying the traffic control device.
Yep.
Here, so I talked to him about it. We reviewed the discovery. I emailed him the discovery as well. And so he's ready to just go ahead and please.
Good. All right, Mr. Frazier, did you discuss your rights and options with counsel?
Yes, sir.
You understand those rights and options? You understand the possible penalty for impaired driving? Understanding that, are you pleading guilty to that charge freely and voluntarily today? All right, did you drive a vehicle in Sumter Township on February 14, 2026? Prior to driving, did you drink alcohol? Counsel, was there a blood or breath test?
Yes.
Would you stipulate?
Yes.
Results were? You think the facts have been met for the impaired?
Yes.
So do I. I'll dismiss the intoxicated or the high BAC and the civil infraction. Mr. Frazier, I'm going to send you downstairs to make an appointment with our probation department to come back for a screening. In the meantime, I'm going to put you on a personal bond. 2 conditions that are pretty obvious: stay out of trouble and show up for court. Third one is do not purchase, possess, or consume any mood altering substance unless you got a doctor's prescription for the substance. Can you live with my rules? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw up on bond? Any questions? Counsel?
You said you have a silver limit or something? Yeah.
Who's got him on a sober link? We don't have him on a sober link. You mean you did that on your own?
Okay.
Proactive, yeah.
Okay.
Yeah, make sure you let probation know that when you come in for your interview. If you go down, you'll have some input on picking that date. So go down to probation. All right. Have a great day, people. You're welcome. Delaware.
All right, let's change things up. Lansing, Michigan, Tony Flores.
That is people, the state of Michigan versus Zachary Schmidt. Around 12. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Zachary Schmidt, who is appearing separately from MDOC.
And sir, you are Zachary Schmidt, is that correct?
That's correct.
All right, thank you. This time set for probable cause conference. Ms. Fortuna Gill, how are we proceeding?
At this time, Your Honor, we are asking this be set for examination.
So we're gonna, is that a fair statement, Ms. Donnelly?
Yes, Your Honor. We have preliminary exam was set last week on March 27th. We'd like to continue to that.
All right, we have the writ date set for next week, March 27th. So we'll leave on for the previously scheduled prelim for March 27th at the prelim is scheduled for 9 and the writ is 8:30. Okay. So at 9 o'clock. Anything else for the record in docket 26-00036? This has been left on for preliminary examination for next week, next Friday at 9 o'clock. Anything else, Ms. Fortuna Gill?
Not for the people.
Ms. Donnelly.
Not for defense.
All right, Mr. Schmidt, we'll see you next week live on March 27th at 9 o'clock. Thank you for your appearance today.
Thank you, Your Honor.
Does Cunningham need to be brought up? Cunningham is here, so we can do that now. You want to do that? Sure.
Which one?
Cunningham, Your Honor.
Jasper Cunningham. All right, so we're on the record in docket 26-00390. That is people of the state of Michigan versus Jasper Cunningham. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Jasper Cunningham, who is standing to my right.
And sir, you are Jasper Cunningham, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Your Honor, at this time, the people need to ask for a one-time adjournment. It appears there was an issue with our subpoenas and the correct officers were not subpoenaed for today's exam. Again, I would ask for this one-time adjournment, and I would ensure that they were here at the next preliminary examination day.
All right, and you've given notice of that to Ms. Donnelly, response, Ms. Donnelly.
Thank you, Your Honor. So we will be objecting to that adjournment. Today is the day set for a preliminary exam. The defendant, Mr. Cunningham, has a right to have this exam within 21 days of his arraignment. So that being today's date, we were asked this case to be dismissed without prejudice.
All right, thank you. The Mr. Cunningham is not incarcerated. He got a PR bond. So I will grant the one-time adjournment for a good cause. So Mr. Cunningham doesn't waive any rights. So the people can subpoena the required witnesses. And then we will reschedule the prelim. You'll need 2 weeks for the prelim for subpoenas.
Please, Your Honor.
Okay, so March 27th at 9 o'clock. This is a good cause adjournment based on the request from the prosecutor's office to subpoena witnesses for the preliminary examination. Mr. Cunningham's not waiving any rights because it is a good cause adjournment, and we've adjourned to March 27th at 9 o'clock. Anything else for the record in docket 26-00390, Ms. Fortuna Gill?
Not for the people, Your Honor.
Ms. Donnelly?
Not for defense.
All right, Mr. Cunningham, we'll see you on March 27th at 9 o'clock.
All right,
Thank you.
Sorry. should be. Are you ready on?
This is Wanji's on.
No, I need to talk to him.
Okay. Oh, Miss Wanji is on?
Yeah.
Okay,
And I need to also talk to him.
then we should be able to call Archer.
Miss Wanji, are you ready on Archer? And you'll have to mute, ma'am.
Yes, Your Honor, thank you.
All right, let's call Jose Archer. So we're on the record in docket 26000569. That is People of the State of Michigan versus Jose Archer. Appearances for the record, Miss Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Miss Wanji.
Good morning, Your Honor. Melanie Biwanji for Mr. Archer, who's appearing from the jail.
And sir, you are Jose Luis Archer.
Yes, Your Honor.
All right, and you can hear me all right, Mr. Archer?
Yes, I can.
All right, thank you. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
At this time, Your Honor, we would be asking that this matter be left on for preliminary examination. An offer has been extended to plea to a domestic violence second. That offer would, of course, remain open until the beginning of the preliminary exam.
All right. And is that a fair statement, Ms. Wanji?
It is, Your Honor. We're going to leave it up for next week. Thank you.
All right, so let's leave on for preliminary examination for March. Let's see. I don't have the right prelim date on here. Is it the 19th? The 13th? The 19th. Okay. So March 19th, 2026 at 8:30. So we'll leave on for preliminary examination for March 19th at 8:30. Anything else for the record in 26000569, Ms. Fortuna Gill?
Not for the people.
Ms. Wanji?
Not for the defense, Your Honor. Thank you.
All right, I'll see you next Thursday morning at 8:30. Thank you for your appearance today, Mr. Archer.
Thank you, ma'am.
And we now have Mr. Jackson.
All right, friends, let's head south, Fulton County, Georgia, Judge McBurney.
Which position is this?
Number one.
Number one, Mr. Bradford. All right. Ms. Smith, are you ready?
I am.
Great. Let's get on the record with position one. It's 25 SC 007-750, State versus Bradford. Mr. Bradford is in court with Ms. Wood, his counsel, and Ms. Smith is here for the state. And Mr. Bradford, my understanding is that you are prepared to enter a plea in your case rather than go to trial. Is that correct?
Yes.
Okay. Ms. Smith is going to put you under oath in just a moment, ask you questions about you, about your case. You need to answer those truthfully and completely. You also need to let me know if you've got your own questions. If something comes up and like, wait, that's not what I thought was going to happen, or it just doesn't make sense. Will you let me know that?
Yes.
Great. And I'll try to explain it if I can. And we'll see if we can get through this. Ms. Smith.
Thank you, Your Honor. Mr. Bradford, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Trouble Bruce Bradford.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given today?
No.
How old are you and how far have you gone in school?
62. 1 year in the college.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We do.
Mr. Bradford, do you remember being arrested on these charges?
I was never arrested on it.
You're in custody now. Did you come from another jurisdiction?
They took me from West Virginia and brought me here.
Okay,
in
so,
2025 on fugitive warrant, they said.
got it. So there's a commitment date of, meaning when you made landfall here of November 21st, 25. That would have been you getting here from West Virginia?
No, I've been here from West Virginia since August. They sent me to Truman PC, and they hold me there, and then they brought me here
Okay.
in November.
November is when you got here, okay? The incident that we're going to talk about today is from long, long ago, 2017. What you're saying is that you were not arrested in 2017 in connection with whatever may have happened at the Life Church.
No, I've never been arrested for that.
Okay. We're not aware of any warrants related to this, other than what got you picked up in West Virginia. Are you aware of any other warrants?
Nope.
Okay.
All right, Mr. Bradford, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years probation?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with another crime in the future, that this plea may be used to enhance that sentencing, even on a federal case?
Yes.
Are you currently on probation?
Nope.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment. Want me to repeat it?
I didn't catch that last one.
Okay. One of the effects of your guilty plea would be your ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Bradford, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No.
As to indictment number 25 SC 007750, how do you plead to count 1, burglary in the second degree, and count 2, criminal trespass and damage to property?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal your guilty plea conviction, but if you believe that there have been some type of error, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes.
Do you understand that that has to be completed within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Thank you, Mr. Bradford. Your Honor, if this case were to proceed to trial, the state would show that on December 23rd, 2017, Officer Copeland with the Atlanta Police Department was dispatched to 3243 Stone Road Southwest, that's in Atlanta, Georgia, also in Fulton County. When the officers got there, they observed a window that was broken, and also blood that was on that window. They were able to see a trail of toys coming out of the church. And at this time, no defendant was on the scene and no one was on the scene. However, as I stated, blood was on the window, a black cell phone was laying on the ground, a gold necklace, and a trail of toys was wrapping around from the window outside of the church. The officers searched the area but did not find the defendant. However, a crime scene analyst came on the scene and took a sample of that blood that was on the window, and it was later confirmed by GBI back in 2025 that the blood belonged to the defendant, Trevelyan Bradford. At that time, officers sought out a warrant for Mr. Bradford, and he was eventually arrested or taken into custody for these charges. And those are the facts of the case. Regarding the negotiated plea between the state and the defense, we've agreed to a sentence of 5 years probation for count 1 and 12 months probation for count 2. For both counts to run concurrent for a total of 5 years probation. For the defendant to complete an anti-theft course, for there to be no contact with the victim or any representatives of the church. Stay away from the incident location, and reserve restitution for the broken window and toys that were stolen from the church that night. And that'll be all from the state, Your Honor.
All right. Ms. Stallworth, do you have any criminal history information on Mr. Bradford?
Yes, Your Honor. He has 24 cycles total, 8 from the state of New York, 3 from West Virginia. There are 6 convictions outside of the 10-year period. I can list them off if you would like.
I'd just like the most recent 2.
There's one in 09 out of Douglas County for burglary, and one in 07 from Cobb County for burglary, impersonating officer, willful obstruction of law enforcement officer, criminal damage to property, 2nd degree, giving false name and false statement or writing.
Got it. And what's the most recent cycle?
1 moment, let me check. This one that is open, before that, it was one in 2019 out of Floyd County.
And that's true across all 3 states? The most recent one is the Floyd County one?
1 moment. The fugitive from justice from West Virginia was July of 2025. That was the last one in that county. And then in New York, I think it was 2014, I'm sorry.
Okay.
It was a misdemeanor assault.
Thank you so much.
You're welcome.
Ms. Wood.
Thank you, Judge. So Mr. Bradford is 62 years old. He does have college education. He does construction work. He's eager to get out and back to work. He's been in custody here 112 days. So he was booked in, as you heard, on November 21st. I do believe he shared with me he was incarcerated in West Virginia since last summer. So he wanted to make sure that that was on the record. And otherwise, we would just ask that you accept the state's recommendation.
Okay. Mr. Bradford, where will home be when you get out? This plea gets you out. So I don't know, it'll be today, should be tomorrow. I'm hearing about different states with which you have connections. Where are you planning on going?
Well, Rome, Georgia, I'll be here in Rome, Georgia until I get an impact compound. But my house is in West Virginia and all my tubes and everything. I do federal work. I remodel projects.
Okay.
Yes.
So your goal would be to get back to West Virginia?
Yes.
All right. You have a place though in Rome to stay?
Yes.
Okay, that's good because it sounds like you know, you can get your probation transferred to another jurisdiction, meaning another state. But it takes a few weeks, there's paperwork involved, et cetera. It's not right away. And while you're waiting, you need to be here in Georgia. But it sounds like you can get a roof over your head.
Yes.
But it'll just be in Rome, which is fine. That's in Georgia.
Yes.
Okay. Do you have any questions about anything we discussed?
No.
Okay. Any reason you would need to be in Georgia after you go back to your place in West Virginia?
Only time I will be coming through Georgia to see my kids. And if we had work here, we had done projects up in Rome, Georgia. We had remodeled the projects in East Rome. Ted.
Your kids are where in Georgia?
I have my oldest daughter is right here in Fulton County. My baby daughter is in Rome. And my other daughter is in Gwinnett.
Okay. And what age range are we talking about? You're 62, so your kids could all be 30?
16,
Okay.
15, 16, and 18.
18. Okay. All right. Thank you. That's helpful. Mr. Bradford, this is a unique case. We don't get a lot of these where a code is hit from long, long ago surfaces and then the state indicts unless it's like a dead body kind of case. But this was a church. I understand why the state went forward on this. I do find there's a factual basis for the two charges and you're pleased to the two charges. I also find that your pleas are knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to enter the plea. Is that correct?
Yes.
I will accept the plea then. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith?
Yes, Judge.
And Mr. Bradford, can we sign for you?
Yes.
We'll do that. I'm going to sentence you, Mr. Bradford, on count 1 to 5 years to serve 3 months. I know you've done more than 3 months, but it's going to be complicated to sort out the credit you get for the time you were in West Virginia. But you get credit for the more than 3 months you've been here, and that just shrinks your probation a little bit. Not much, but hey, every month counts. So 5 years to serve 3 months, balance on probation. Special condition of probation is that there are 2 of them. One is that you stay away from the Life Church, but I can make that easier because number 2 is that you will stay out of the state of Georgia other than the Rome Judicial Circuit, which is Floyd County. So you can go there now. That's going to be okay. And you can stay there until you get your probation transferred to West Virginia. If you want to come back here to visit family, you go to Floyd and people come to visit you. You don't go to Gwinnett. You don't go to Fulton. If you're going to be in Georgia, there is no issue if you're in Floyd County. If you're outside of Floyd County and you were to get pulled over for a speeding ticket or anything like that, that would be a violation of your probation. And the state could, I don't know if they would, but they could say, let's get a warrant and do something about that. So you can pass through, obviously, because there's probably an airport in Rome, but not the kind of airport you're going to fly into. But if you're staying in Georgia, Floyd County only. The rest of the country is yours. All right? We may regroup if there is restitution, but I'll leave that to the state. And you'll need to work with Georgia probation to figure out the paperwork you need to do through ICOTS to get your case transferred to West Virginia.
Is it a possibility I could get restitution waived? Because right now I have nothing. All my money went to having my ex-wife buried.
So 2 things. 1, I'm sorry about the burial. 2, what I'm going to do is waive your probation supervision fees. That's something different than restitution. I'm going to waive your probation supervision fees for the first 2 months while you get back on your feet. Now, you may already be back in West Virginia by then, but if you're still in Georgia, you'll not have to pay the supervision fees for the first 2 months. Restitution is different. I don't know that we'll have the hearing, but if we do, you would have the opportunity to present your ability to pay. So the state would have to prove up amounts owed, how much it cost to fix the window, we lost these toys, whatever it would be. I'm gonna make a number up. That's $1,000. You're not expected to right then stroke a check for $1,000. You would pay as you are able over time, as you are earning, supporting your family, et cetera. So it's something you'd be obligated to pay, but not all at once. And it never results in you going back to jail. We don't do it that way. But if you are spending money on fancy new cars, we might say, you know what, you can't do that anymore. You got to pay $100 a week going forward to do that. But that's only if we end up having the restitution hearing. And I don't know that we will. Okay. Ms. Wood, anything else?
No, Your Honor, thank you.
Ms. Smith?
Nothing further, thank you.
All right. You're going to need to report to probation within 48 hours after your release. Ms. Simpson, who is with probation, is going to come talk to you about that. Because if you're going straight to Rome, she'll let you know where in Floyd County the probation office is. He is. Oh, I meant to ask you, these are old convictions, but you're on probation in Floyd County.
He had
My probation
revocation
supposed to be
in
finished.
August, the PDC, and he finished the PDC. It was a sanction here.
Okay, it must have been a short PDC
It
stay.
was a 20-day sanction,
Got it.
and when he completed it, he was transferred.
Oh, well, Mr. Bradford, you weren't quite candid with me. You made it sound like, man, it took forever to get to Fulton because it was a long trip from West Virginia, but you had another stop.
No, because when I was told I was a fugitive for Fulton County, not for Floyd County, because my probation was finished in Floyd County.
Well, I guess they saw it differently and you spent some time up there. It doesn't change anything here, but it sounds like you know where probation is in Floyd.
Yes, I know where probation is.
That's where you'll need to go within 48 hours of your release.
Okay.
That's it.
Judge.
All right.
Good luck, Mr. Bradford.
When in Rome, friends, when in Rome. Let's go back to Ohio and Judge O'Donnell.
We went through the series of questions, all the rights. Mr. Bland, he acknowledged all the rights, waived all the rights, and he had Ms. Bell recite the facts upon which the guilty plea was based. And asked Mr. Bland if what Ms. Bell said was true, and his answer was the effect of, well, not really, or something like that. And I asked him what occurred, and he really didn't say anything.
Yes, sir.
So why don't we do this before we, because if you're gonna plead guilty, we have to go through the acknowledgement and waiver of rights once again, and then get to the facts of what occurred in order for there to be a finding of guilty. So why don't we do this? Why don't we preliminarily have you tell me, because you wrote something down, what occurred, and then we'll see if we go forward with the acknowledgement and waiver of rights. So why don't you tell me whatever it is you want to tell me?
Yes, Your Honor. Today I write this letter to the Honorable Judge and understanding that today I will be entering a guilty plea of judgment. On July 8th, 2025, in a moment of absolute fear and panic, I made the wrong decision operating my vehicle at very dangerous high rates of speed. I now realize that no matter how afraid I was, that doesn't excuse my actions. I want to take full responsibility for my lapse in judgment, Your Honor. I want to express deep remorse to law enforcement officers and everyone else who were involved or could have been involved. In this incident, I take full accountability for my lapse in judgment, Your Honor. And knowing next time it is best to stop and follow the rules of traffic and law. Thank you for your time. Respectfully, Kyrie Bland.
Okay, so Mr. Bland, so this panic set in when you saw that they were trying to pull you over?
Yes, sir.
Okay. All right, how old are you?
24.
And how far did you go through school?
High school.
Are you a U.S. citizen?
Yes, sir.
And you're able to read, write, and understand the English language?
Yes, sir.
Prior to coming here in the last 48 hours, have you taken any drugs, alcohol, or any prescription medication?
No, sir.
Have you ever been diagnosed with?
No, sir.
All right. Now, you got a copy of this charge, right, this indictment?
Yes.
All right. Do you have any questions about it?
No, sir.
All right. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you questions. If you don't understand the question, stop me. If you want to talk to Mr. Mulkey some more, let me know that, and I'll give you more time. Do you understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand that the prosecutor has to prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, then I'll issue an order that's called a subpoena to make them come here and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you decided not to testify at trial, nobody is allowed to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to get a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you could not afford a copy of the transcripts, they'd be given to you free of charge. Do you understand that?
Yes, sir.
If you plead guilty today, you do not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to this charge?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
Yes, sir.
Now, this failure to comply with the order or signal of a police officer is a felony of the 3rd degree. It carries a 60-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes, sir.
The class 2, is that a 3 to life?
Yes, Your Honor.
Okay. Do you understand that the conviction on this case would carry a driver's license suspension of at least 3 years up to your lifetime?
Yes, sir.
Do you understand if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes, sir.
If you were placed on post-release control and violated any conditions, a parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If the violation were a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that were to occur, the maximum prison sentence for that violation would be either 12 months or the time left under post-release control, whichever is more. Do you understand that?
Yes, sir.
Do you understand that if a prison term is imposed in this case, you would be eligible for judicial release?
Yes, sir.
I could place you on community control for up to 5 years, but if you violated any conditions, I could send you to prison for 60 months. Do you understand that?
Yes, sir.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk to Mr. Mulkey before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions at this point in time?
No.
All right, Ms. Bell, Mr. Bland indicated at the start of this hearing the activity he engaged in. Does that satisfy the state that those facts as recited by Mr. Bland would result in a guilty verdict if shown at trial?
I believe so, Your Honor. The state would just add that the operation of that motor vehicle caused a substantial risk of serious physical harm to persons or property.
All right. Mr. Bland, based on your recitation with what Ms. Bell added, what is your plea to the charge of failure to comply with the order or signal of a police officer?
I plead guilty, Your Honor.
Okay. Bob, would you find out? Maria had a date of 4/15, but that was as of early last week. So we're probably going to have to move it back. Yeah, maybe a week or so. Signature here, and then date it here, 3/12.
Your Honor, eyewitness defendant signed the written plea guilty. Mr. Mulkey and I have signed the same.
Okay, Mr. Bland, is this your signature on the written plea of guilty?
Yes, sir.
And did you sign it voluntarily?
Yes.
And do you want me to accept your written plea of guilty?
Yes, sir.
All right, I will accept the written plea of guilty. Mr. Bland was present with Mr. Mulkey, advised of all of his rights, made a knowing, intelligent, and voluntary waiver. He understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary, will accept the plea of guilty and find him guilty of failure to comply with the order or signal of a police officer, a felony of the 3rd degree. And refer this for a pre-sentence report. The sentencing will be April 15th, I think, at 2 p.m. Wait till Bob comes back.
Judge, that's the date.
That's the new date, right?
Yes, new date.
Okay, all right, yeah, 4:15 at 2 o'clock, and the bond is continued. Anything else, Ms. Bell?
Nothing further, Your Honor. Thank you.
Mr. Mulkey?
No, Your Honor, thank you.
Okay, we're adjourned.
Okie dokie, friends. Join us tonight right here on this channel for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. We will be talking about streaming live courtrooms here on YouTube. Is it fair? Is it right? Do people complain too much about it? Do they have a point? All those kind of things will be discussed. This is kind of off the back of Judge Boyd losing her primary, in part, actually probably in whole, because her opponent was screaming bloody murder about her streaming her court. So that'll kind of be the jumping off point for tonight's discussion. So be sure to join us. I think that'll be fun. Also, in the 4th hour, the bottom half of the 4th hour, so about 45 minutes from now, we will be having a little bit of a discussion on a story I brought you a couple of days ago. If you'll recall, we talked about a set of kids who TP'd a teacher's home, and the teacher came out to pursue them, and he fell in the street and got run over by one of the kids fleeing in their automobile and was killed. Well, there's been a development, so we're going to talk about that in the bottom of the 4th hour because it got interesting. Anyways, not that it wasn't interesting before, but even more so now. Anyways, let's go back to Judge McBurney, new contestant.
I'll ask All right. Good morning, Mr. Rhodes.
Good morning, Mr. McBurney.
How you doing?
I can't call. I'm blessed. I woke up this morning. See
You
another.
did wake up. Me too. So we're on the same footing there. Mr. Rhodes, Mr. Jerome tells me that you are prepared to enter pleas, not just in one, but both your cases now. Is that correct?
Yes, sir.
Sounds like we have a global resolution, as we call it. Okay. That's 24 SC 006 456 and 25 SC 005 983. There are two different prosecutors involved in the case. And just so you know, it sounds like Ms. Smith, it looks like Ms. Smith, because she's seated here, will be asking you most of the questions. Ms. Reese, who is standing to your left, may have questions for you. She's handling the case involving the cruelty to animals, but it may be she's simply relaying to me what she believes the facts are in that case.
Yes, sir.
Just so you know, there are two different lawyers for the state because your case is within that office. All right. Ms. Smith will put you under oath. Once you're under oath, please answer all the questions truthfully. If at any point you need to speak with Mr. Jerome privately, let me know. And if at any point you have questions, let me know.
Yes, sir.
Ms. Smith.
Thank you, Judge. Mr. Rhodes, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name.
Kyrie Omarion Rhodes.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
22 years old, and the beginning of 12th grade year.
Do you have your GED or you
No, sir.
got into your senior year?
I got into my senior year.
Okay.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with his services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Rose, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
Do you understand that this is a negotiated plea for both cases, which means that the state will recommend to the court a global sentence of 10 years to serve one with the balance probated?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, even on a federal case?
Yes, ma'am.
Are you currently on probation?
No, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial?
Yes,
For
ma'am.
example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or your ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Rhodes, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment 24 SC 006456, how do you plead to count 1, driving, fleeing, and attempting to elude; count 2, theft by receiving stolen property; count 3, willful obstruction of law enforcement officers; and count 4, driving without a valid license?
Guilty.
Regarding indictment number 25 SC 005983, how do you plead to count 1, aggravated assault; count 2, aggravated cruelty to animals; count 3, possession of a firearm or knife during the commission.
Hold on one second.
We will be on prosecuting count 4 and 5.
Okay.
I'm sorry, I didn't hear that.
So, in the indictment ending in 983, the state is dismissing count 4 reckless conduct and count 5 discharge of a firearm near a public highway. So the 2 misdemeanors, the state is dismissing.
Thank you.
You're welcome.
And I'll just repeat that. As to indictment number 25 SC 005983, how do you plead to count 1, aggravated assault, count 2, aggravated cruelty to animals, and count 3, possession of firearm or knife during the commission of or attempt to commit certain felonies?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal from your guilty plea conviction, but if you believe that there has been some type of error, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes, ma'am.
Do you understand that this has to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Thank you, Mr. Rose. Your Honor, regarding indictment ending in 6456, if this case were to proceed to trial, the state would show that on February 18th, 2023, around 11:30 p.m., Corporal Brine, that's BYRNE, received a flock hit notification for a stolen white Kia Forte in the area of Washington Road and Desert Drive. That is in Atlanta, Georgia, and also in Fulton County. While the officer was canvassing this area, he did notice that white Kia Forte and initiated a stop based on that flock hit. When the officers put on their lights, the vehicle began to flee and started to drive on the wrong side of the roadway and also down Mount Olive Road. That road had a dead end. So when the car got up on that dead end, the driver, who was identified as the defendant, Kyrie Rhodes, he drove through the gate of the house that was at 3177 Mount Olive Road. At that time, Mr. Rhodes and 3 other occupants of the car got out and started to flee on foot. Mr. Rhodes was found during this foot race, and he was placed under arrest for the charges we have in front of us. The car was confirmed that it was stolen through GCIC, and also that block hit that the officers were able to receive and and that's the reason why they pulled over the car. But those are the facts and circumstances regarding the case regarding the facts in this case. And then, as previously stated, for the charges we have here, there would be a global offer of 10 years to serve 1. Did you want me to break down the sentences for each count?
I think I can do that. Well, but let me make sure. It's a felony for count 1, and then the other 2 are, and count 2, the stolen car, and then 2 misdemeanors.
That's correct.
Okay, got it. No, what I'd like to do now is hear from Ms. Reese about the factual basis for the case ending in 983. And I need you to be near a microphone because Ms. Rivers couldn't hear you. So you can either take a seat in the middle of the prosecution table or that's probably your best bet. Thank you.
Judge, if this case went to trial, the state would expect the evidence to show that on March the 3rd of 2025, East Point Police Department were called to 1420 Pine Avenue in Fulton County regarding a dog being shot. When the officer arrived on the scene, he talked to Akeisha Graham, who is the victim of the ag assault. She told him that she had been inside her house there at 1420 Pine Avenue, and she had 2 dogs outside in the yard. She heard a commotion going outside, so she went out of the residence and observed one of her dogs outside of the fence. Somehow the dog had gotten out, evidently had bitten someone. So she got that dog and brought it back into the house. Shortly after that, she was confronted in the house by someone that she recognized from the neighborhood who turned out to be the defendant in this case. She didn't know his name, but she knew who he was. She stated that he had come onto the property, armed with a firearm, demanding to see the dog that had bitten the other individual. He was declaring that he was there to kill it for attacking his girlfriend. He pointed the firearm at her, and she got scared and ran back in the house, and she heard 3 gunshots. When she later went out in the yard, there was one of her dogs, not the one that had gotten out earlier, but a dog that was chained up in the yard, at least 15 feet from the fence, laying dead on the ground. Police also observed the dog dead on the ground. Officers showed
2 dogs or 1 dog?
1 dog,
Okay,
but it was not the dog.
the wrong dog.
It was the wrong dog.
Not that there's a right dog to go and shoot.
Not
but
once they were chained
Not
up.
the one that bit someone.
So the police showed the victim in this case a photo of the defendant, and she positively identified him as being the one that pointed the gun at her, Judge. Judge, as part of the sentence, there is that possession, which has to be added consecutive.
Okay, but in this case, not the other case.
In
So,
this case, yes, sir.
I could make the first 2 counts 5 to serve 1, and then the third count 5 consecutive.
Yes, sir.
Okay,
And
understood.
suspended. And the conditions of his probation? Special terms? No, cannot possess any guns or replica of guns. Cannot own, control, or possess any domesticated animals. He has to be gainfully employed. Take parenting classes. Random drug and alcohol screens. GED, I believe he said he had not graduated. He is to stay away from the location of 1420 Pine Avenue and have no contact with the victims Dexter Whitehead and Keisha Graham. At least Dexter owned the dog.
Parenting classes?
Yes, sir, Judge, because there were a lot of children around when he was discharging the gun.
Okay. Got it. Are there people here from Ms. Graham's family who want to be heard? Someone's raising a hand. Or are there people here with Mr. Rhodes?
Yeah, that's Mr. Rhodes' family.
Okay, well, we'll get to that in just a moment.
Yes, Your Honor.
Okay, thank you, Ms. Reese. Did you have other conditions of probation?
Yes, I failed to mention, my apologies.
Okay.
The state is going to be requesting for the defendant to complete an anti-theft course, to complete a defensive driving course, and to maintain gainful employment.
Got it. Okay. And there's no restitution that you're aware of owed to the owner of the Kia?
That's correct.
Okay. All right. Ms. Stallworth, criminal history info on Mr. Rhodes, please.
He has 3 cycles, no convictions listed, and 1 FTA in 2025 out of Fulton. Nothing further.
Thank you. Mr. Jerome.
Yes, Your Honor. In terms of the fleeing case, there's nothing that we're going to say in regards to that. We're just asking that the court accept that plea is negotiated. In terms of the dog case, you've essentially heard the facts. The only additional thing that we'd like to add is that even though the dog was on the leash, Mr. Rhodes didn't know it at the time, and the dog actually came at him. And it was apparently a very long leash that this dog was on. And this is not the first time the dogs have been loose in the neighborhood. And this is not the first time that someone has been bitten by one of their dogs, and they have several dogs. So it's hard to distinguish them individually. Though we felt, anyhow, we believe that this is a reasonable plea in this case. And we just ask that the court accept the plea as negotiated.
Appreciate the context. Is it nonetheless accurate that the dog on a long lead or a short lead was inside a fenced yard into which Mr. Rhodes had entered?
So Mr. Rhodes wasn't in the yard. He was at the gate of the yard, and he was actually arguing with the owner of the dog.
And would that be the gentleman's name I heard, or arguing with Ms. Graham?
No, that's the gentleman. That's her father. So,
Okay.
My understanding is that Ms. Graham he never even saw Ms. Graham. So, but he was arguing with the gentleman that was there. And then the dog was basically running up behind him. And because, they normally have their dogs out without a leash, he was under the impression again that this dog also did not have a leash on him. Though he was in the yard, the dog was only about 5 or 10 feet away from him. So it wasn't as if he shot, across several homes or whatever the case may be. But, and Mr. Rhodes was not in the yard. He was actually standing at the gate. He was standing at the gate speaking to the owner.
But if he had a fence between him and the dog, I guess I'm trying to understand the need to shoot the dog.
The gate was open.
Okay.
Yeah, it was open.
Okay. Got it. Mr. Rhodes, anything you want to add?
But what he just said, I never had verbal or visible confrontation with Miss Keisha Graham. I only verbally spoke to her father, and
That's Mr. Whitehead. Am I remembering the name? Okay.
and
Were you a neighbor? Did you live nearby?
no, I stayed down the street on the other side of the neighborhood.
Okay.
We all just used to play basketball right there next to her driveway. We used to have a basketball goal there.
Okay. When you get out, will you be living close to that household? Do you have a different place to stay?
No, sir. Yeah, I moved to Union City.
Good. That's going to make a lot of this simpler. But was there more you wanted to say? I don't mean to cut you off, other than you're helping me understand that you were having an exchange with Mr. Whitehead, not with Ms. Graham.
Yeah, but
Okay.
then when the dog situation happened, it wasn't how she was saying it. I never even got to speak to her until she came out, passing along the threats and whatever. When I had grabbed my baby mom and we was walking up the street to go to the hospital. That's it.
Okay. So when you say baby mama, I might say girlfriend. This is the person who got bit?
Yes, ma'am. Yes,
Okay.
sir.
And she had to go to the hospital as a result?
Yes, sir. She got bit. The dog bit through and through her breast and bit through a bone in her finger.
Okay. And you're saying that's not the first time people in your neighborhood had unwelcome encounters with one or both of those dogs?
No, sir.
Okay.
His dogs, he had the dogs for the purpose of being protectors or being aggressive, and he don't have a fence to where he can close it. He just pull it up, and his dogs run freely through the yard so they can burst out whenever. So if you ride past on a scooter or you walk past and the dogs are outside, they can burst out whenever they want to.
Okay. And how many times did you shoot the dog?
That I don't recall.
Okay. But you're not saying you didn't shoot the dog. You're just helping me understand a little bit more why you might have thought that was necessary.
Yes, sir.
Okay. As you think back on it now, what could you do differently if you found yourself with your girlfriend in that situation?
Call law enforcement.
That's an approach that let them deal with it. Because I'll tell you what, if the officer shoots the dog, no one's going to jail. Someone may get sued, but Mr. Rhodes doesn't spend 190 days in jail as a result of that. You have a right to be safe and you have a right to protect your girlfriend. But you got to be careful about how that plays out.
Yes,
And
sir.
it sounds like this is one that the way it broke, it didn't go real well for you. Obviously didn't go well for the dog. Okay. Well, I appreciate you articulating that. That was a thoughtful way of presenting it. And you're giving context. You're not blaming the whole world. You did some things and the dog did some things.
Oh, yeah, no, I'm taking full accountability for everything that I
Okay.
did do.
And it sounds like the knucklehead thing that was going on back in 2023, that's just you. You can't blame a dog for that one.
No, sir.
Okay. All right. How many kids do you have?
One right now.
One right now. Like if I were to ask you in 3 months, how many kids would you have?
I say probably. My mom.
He's looking back.
My mama in here. I ain't gonna say that.
Okay. Okay. Got it. All right. Well, Mr. Rhodes, I find there's a factual basis for both your cases. I understand better now that I've heard more about the second case, while Mr. Jerome was needing to work harder on your behalf to resolve the case where you discharged a firearm, which is always a risky thing. It's tragic that the dog was hit and killed. The maybe larger concern that a lot of people have is that you're shooting and things are going this way and that way, and maybe Mr. Whitehead gets hit accidentally. You don't mean to do it, but he's saying, "Don't, what are you doing?" And then you hit him in the leg and he bleeds out. And then we're not talking about a cruelty to animals charge. We're talking about 30 years for you or life for you.
Correct.
It's just a reason to be super careful when you put your finger on a trigger. Because once that bullet comes out, you don't control what happens. And it goes through Mr. Whitehead instead of that dog. And Mr. Jerome is very good at what he does. He's not that good. We wouldn't be talking about a year or GED. It would be however many kids you have, they're going to watch you grow up down in Reedsville or something like that.
Right.
And I say that not to sound like I don't get it, just so you understand the stakes that are involved when you pull that thing out. And now that you're going to have this sentence, there'll be the double whammy of you'll be a felon and you get caught with a gun just in your car. Your hand doesn't need to be anywhere near it. That's going to be more jail time. So really your gun days are done. Have a baseball bat or something if a dog's coming at you, but no more guns. Okay.
Yes, sir.
I find a factual basis for both your pleas. I find that your pleas are knowing and voluntary, meaning you've understood what we've been talking about and no one is forcing you to enter your pleas. Do you agree with that?
Yes, sir.
Mr. Jerome, can we sign your name, someone in my office sign your name to both indictments?
Yes, Your Honor. And
You have a question.
Yes. So another issue is that he's actually in school. He's not working. So we wanted to see if it could be work or school.
I'll get to that.
All right.
Yeah, when we get to the conditions. But we can sign your name to both indictments.
Yes, you can.
And Ms. Smith, can we sign your name to the indictment ending in 456?
Yes, sir.
And Ms. Reese, can we sign your name to the indictment ending in 983?
Yes, sir.
Okay. And Mr. Rhodes, can we sign your name to both indictments?
Yes, sir.
All right. In the driving a car fast and crashing and running and all that case ending in 456, I'm sentencing you on count 1 to 5 years to serve 1 year with a balance on probation. Count 2 is 5 years to serve, not 5 years to serve, 5 years probated, running consecutive to count 1, and counts 3 and 4 are misdemeanors, and those will both be 12 months to serve. And they'll run concurrently with count 1. So that's 10 to serve 1, balance probated. You'll get credit for the time you've been in, which by my math is 191 days, so over half of the sentence already. Special conditions of your probation in that case, 1 will be get your GED. It sounds like you're already trending in that direction. And then 2, you'll need to complete a defensive driving course.
Yes, sir.
That's it. In the other case, ending in 983, before I sentence you, I forgot to ask Ms. Reese, was there any information that you had from either Ms. Graham or Mr. Whitehead that they wanted me to hear?
No.
Okay, thank you. Your sentence in the second case is 5 years to serve 1 year as to counts 1 and 2. Those will run concurrently with each other. And then the third count has to run consecutively, and it has to be 5 years, but I'll probate that. So that's a total of 10 years to serve 1 year, balance probated. That sentence will run concurrently with your sentence in the other case. Special conditions in the case ending in 983, get your GED. You can have no pets in your household. So if you're living with other people and they had pets, those pets need to not be in the household. This is while you're on probation. It's not forever, but while you're on probation. You need to submit, what was the drug and alcohol screen situation? Was there a reason for that? You just seem to be reading a laundry list of stuff. And
The notes Hollander left for me, Judge.
Okay.
This is not my case.
all right, I'm not going to include that. Probation's free to do that. If probation's interacting with you like, hey, this guy is acting a little funny or he smells like weed, they can get you to take a drug test. They have that ability throughout probation. You will need to stay away from both Ms. Graham and Mr. Whitehead. So if you see them somewhere else, I know you live somewhere else now, you got to walk away. And you need to stay away from 1420 Pine Avenue. So if you have family that still lives there, they need to come see you. You can't go back to that street and that neighborhood. And as for the work and school, you need to be either enrolled as a full-time student or working at least 20 hours a week while you're on probation, okay? I think I covered everything. Anything else, Ms. Smith from the state? Ms. Reese?
Nothing further.
Mr. Jerome, I think I addressed your concern about, well, wait, if he is in school full-time, how's he going to be working full-time? He doesn't need to. You can work as much as you want, but if you're not working, you better be a full-time student. All right? Any questions about any of that, Mr. Rhodes?
Only the question I asked you.
Well, Your Honor, can he serve the remainder of his time? Because he's already been in for over 7 months. He wants to serve the remainder at the county jail. He doesn't want to be sent to a state facility.
So fair question. I don't control that. My experience is that typically when there's less than 6 months left on a sentence, you stay put. But as you know, because you're living it, the jail is very full. And so the sheriff's team is also looking at who's been sentenced and can we send them somewhere. There's not a whole lot of point sending you to Jackson if you're going to just be there for, I mean, these are all parolable offenses. And so why send you to Jackson for 5 weeks or whatever it might be? I'm not promising you any exit date other than it won't be more than a total of a year, including all the time you've served. So my guess is you'll stay put, but I don't control that.
Yes, sir.
Okay. All right. Thank you, Mr. Jerome. That is it for those 2 cases.
Thank you. May I be excused?
Yes.
Okie dokie, friends. Fulfilling this channel's promise of 9 to 11% more, Judge Boyd. Let's go there.
All right, court is calling 2026 CR 001908, State versus Salvador Gonzalez. Can I have parties announced?
Ray Lopez for the defense.
And are you Mr. Gonzalez?
Yes, sir.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Gonzalez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? You need to speak up. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 38 days in the Bexar County Jail on a 1244. There's an $800 fine and no applications. Did you understand that to be the plea? Defense?
It is, Your Honor.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, I do.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after viewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We would just ask the court to follow the plea bargaining agreement.
Right. Who is Miss Dennis to you? Dennis.
Dennis. Person who's in the car, something.
In the phone?
Yeah.
Okay. All right, this court is going to do, the court will find you guilty, sentence you to 38 days in the Bear County in the Bear County Jail under 1244. Give you credit for any time served. There is an $800 fine. Time and money will run concurrent, and there's to be no contact with Dorothy Dennis. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. You're gonna have to start making better choices. If you have a drug issue, there are plenty of places that can help you when you're released from the Bear County Jail. If you can't find a place, come back here and I'll help you. All right, good luck to you.
Thank you.
You're welcome.
Hopefully she's still there to help him, depending on when he gets out. Anywho, back to Judge Mom.
Your Honor, John Bull, 30758 on behalf of Ms. Donald. Ms. Donald, please put your name on the record.
Chelsea Donald. Good morning. And so today is the date scheduled for the probation violation. Your client is on probation for operating while visibly impaired. Your client was sentenced on January 13th of 2026, and it's alleged on February 9th that she tested positive for alcohol. Counsel?
Your Honor, I've had an opportunity to discuss this matter with Ms. Donald. I've explained to her a right to a hearing in this particular matter. Also explained to her what the recommendation from this court was. With that said, Your Honor, she wishes to plead guilty to the violation of probation, understanding that by entering into this plea, she'll be waiving certain constitutional rights. Is that correct?
Yes. Okay, so ma'am, I'm going to have you please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth? I do. I'm sorry? Yes. All right, thank you. Please keep your hands out of your pockets. And you heard the plea that was placed on the record, correct? Yes. I'm sorry? Yes. Okay, I need you to adjust the microphone because we have to pick up everything you're saying for our recording, okay? And as to the allegation, ma'am, that you tested positive for alcohol on February 9th, how do you plead? Guilty. You've gone over your advice of rights with your attorney, correct? Yes. And you understand all of those rights? Yes. You understand that for probation violation purposes, that you'll be waiving some of those rights? Yes. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? Yes. And you understand the possible penalty as a result of your plea? Yes. And the recommendation in this matter is for you to continue and complete all terms of probation, pay a $50 probation violation fee, and 30 days on the alcohol tether, and then increased testing. You understand that? That's the recommendation. Yes. Knowing all that, do you want to continue with your plea? Yes. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? No. Any immigration issues? No. Counsel, if you can please run to your client.
Thank you. Ms. Donald, you were placed on probation to this court. Is that correct?
Yes.
And one of the terms and conditions of probation was to test for alcohol and or drugs when required. Is that correct?
Yes.
And on February 9th of 2026, did you take a drug test?
Yes.
And did you test positive?
Yeah.
And was
Is that
that,
yes?
Yes.
and you tested positive for alcohol, is that correct?
Yes.
And this is in violation of your terms and conditions of probation, is that correct?
Yes.
And satisfies your honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation, indicate technical violation number 1. And counsel.
Your Honor, as to the recommendation, Your Honor, we have discussed this matter. This was elapsed by Ms. Donald. She's contrite. She understands this was not the way to start her probationary period with this court. I note that she has in other areas done a great job, a lot better than we see a lot of people. In other words, she paid the cost of fines up to an amount. She has been taking the classes. She's also scheduled for the
That education class.
education classes. They will start in March. She is remorseful, Your Honor. As to the recommendation, we ask your recommendation be adopted. However, rather than a alcohol tether, unless the court is willing to accept that she will test cleanly, we ask for an for a sober link.
Why? Why should I offer your client a sober link as opposed to the alcohol tether?
Your Honor, because Ms. Donald works for the U.S. Postal Service.
Yeah.
She is a letter carrier, and she's fearful that this may have some adverse effect from her employment with the tether.
Okay, and so ma'am, that's all in your control.
Yeah.
Had you not violated probation, this wouldn't even be an issue. What, so what happened why'd you consume alcohol?
I had a weak moment and I've just been very depressed.
Okay,
take forward.
are you treating with the doctors?
Huh?
Are you treating with the doctor for your depression?
I made an appointment right after recently. I go next Tuesday.
All right. Anything else you want the court to know?
No.
There's a tissue underneath the podium there if you'd like. All right, the court's going to do a sober link, ma'am, just so you're aware, you're testing 6 times a day, so you will be your sleep will be interrupted so that you can do your testing. And then you'll also have to increase your random testing as well. So you're going to, and then the court's going to continue your probation, you're to continue and complete out terms of probation. And then you are to stop at probation and you'll get all of your information about obtaining the sober link and then the new color. Okay?
Thank you very
Good luck
much.
to you, ma'am. Thank you.
All right, and let's, before we get to the story I wanted to cover, let's go back to Judge Oakley one more time.
Good morning, ma'am.
Your Honor, today's date, time set for Raymond in this matter, we wait for reading and stand. You also had a chance to pre-trial this case, Your Honor. That's the subject.
Tell me all about it.
In that agreement, this victim was pleading guilty to an added count of operating while visibly impaired and failure to accident with the understanding all the 4 original charges with the dismissed.
That young man have anybody with him today?
No, Your Honor.
He got your phone number? Catch him, make sure he talks to Mr. Body before he gets out of here. Where is he?
He's waiting for his notice.
Right.
Make sure you speak to counsel before you leave. They understand that.
If you've got anything that I should know before I send you to jail, you talk to him about it. I just threw you a lifeline, brother. You're welcome. Go ahead. Counsel, go ahead, Ms. Baker.
Your Honor, you want me to go out here?
Did we get to the plea yet?
Yes, sir.
All right.
2 charges, operating while physically impaired and failure to report an accident.
Okay,
Original charges would be.
voir dire.
The offense-
Hold on a minute. You understand your rights? You understand the options they give you? You understand the possible penalties? You're pleading guilty or no contest?
No contest.
You understand when you say no contest, you're saying, Judge, I'm not fighting those charges. You're doing all that freely and voluntarily?
Your Honor,
Do you have a,
civil litigation,
do you have an incident report? Because a voir dire is not gonna work with a no contest.
I think I think the prosecutor has it on his phone.
Doesn't do me any good. I gotta have the facts. I can pass on the file.
Yes, Your Honor.
Okay,
Fine.
all right. Ms. Baker, have a seat.
Okie dokie, friends. Let's transition. So I believe it was on Monday, we talked about a case out of Gainesville, Georgia. And if you'll recall, it was incredibly tragic. So what happened was some kids were playing a prank on one of their teachers. I believe it was 4 of them, if I recall correctly. Maybe it was 5. They were all 18. They showed up at the teacher's house to TP it. The teacher saw them and made a move to intercept them. And in his doing that and running after them, he tripped and fell into the street. And as the teens were fleeing in their vehicles, one of them was in a truck and he ran the teacher over, and the teacher was killed. We have new information. There's a news story on this, and I want to go through it with you. Pay specific attention to the details at the end of this story. All right, let's pull it up here. Give me just a second. Let me pull this back up. All right. So, teen charged in senior prank gone wrong makes vow after teacher's death. 18-year-old Georgia high school student charged in a teacher's death is expressing his deepest sorrow after an annual prank turned tragic. 5 North Hall High students were arrested after they arrived at a math teacher Jason Hughes' home carrying toilet paper with plans to carry out the annual prank tradition, in which Hughes was the target. As the group went to leave Hughes' Gainesville home in 2 separate vehicles, teacher fell in the roadway. We know these details. Wallace issued a separate statement vowing to live out the rest of his life in a way that would honor Hughes. I pledge to live out the remainder of my life in a manner that honors the memory of Coach Hughes by exemplifying Christ. We will never be forgotten, or he will never be forgotten. Wallace's family issued a statement expressing their sadness regarding the incident. We are a family in deep remorse and grieving over such tremendous loss in our North Hall community, Wallace's family said in a statement. Jason Hughes meant the world to our son, Jaden. He took the time to invest in Jay and poured his love into him, making lasting impact along with the rest of the family. Jay expresses his deepest sorrow and sincerest apologies to the Hughes family. Immediately following the collision, authorities said the students tried to render aid as they awaited first responders. Hughes later died from his injuries. Wallace was subsequently taken into custody and charged with felony first-degree vehicular homicide and reckless driving, along with misdemeanor charges for criminal trespass and littering on private property. The other 18-year-olds, identified as these people whose names I don't really need to read, were also arrested at the scene and charged with misdemeanor criminal trespass and littering on private property. All 5 have since been released on bond. In a statement to the New York Times, Hughes' wife, Laura, said the father of 2 was this is where I want you to pay attention. Okay. Hughes' wife, Laura, said the father of 2 was excited and waiting to catch them in the act when the group arrived at his home. This is a terrible tragedy, and our family is determined to prevent a separate tragedy from occurring, ruining the lives of these students. This would be counter to Jason's lifelong dedication of investing in the lives of these children. The married couple both work as teachers at the public school, and the popular prank had turned into an ongoing battle in which students lost points if the teacher caught them in the act. In a statement to Fox 5, the school said, "Our hearts are broken. Jason Hughes was a loving husband, devoted father, past and teacher, mentor, and coach, loved and respected. He gave so much to many of us in numerous ways. Our hearts go out," on and on. But pay attention to that. A popular prank had turned into an ongoing battle in which the students lost points if the teacher caught them in the act. And Laura Hughes, his wife, saying that he was excited and waiting to catch them in the act. That completely changes the tenor of this whole thing for me. So I do so much content at this point. I don't remember which show we talked about this on. I don't remember if it was Sidebar, In the Blind, or what. But on one of these, we touched on the idea of the quality of people that we turn our children over to. And I'm not trying to put a stain on this man's name. But I raised the point that we turn our children over to teachers to raise them practically, but we don't pay a whole lot of attention to what it is exactly that these teachers are doing with these students. We don't pay attention to the character of these teachers. We're not giving a whole lot of emphasis and thought into what goes on a day-to-day basis. How are they really leading our children? And my biggest issue here with this revelation is that this was encouraged behavior. It was a friendly behavior. There's not a boundary there between student and teacher. There should have been a clear boundary there. This never, ever should have happened. No teacher should have ever been encouraging this. And in fact, the school issued a statement a day or two prior to this saying that we have to be careful about pranks getting out of control. So the school knew that this stuff was going on. The teacher was excited to be a part of it, and now the teacher is dead. Now, you can look at that and say, "Yeah, Dan, it's just TPing. It's a tragic thing." I get that. But every time you go and take a step into something that is not right, you are one step closer to something that is very wrong. And we see that play out in these courts all the time. People make one or two dumb choices, and the next thing you know, they're popped for something major. Like a super drunk because they had a bad day and made the choice to go to the bar and have one or two drinks that turned into 5 or 6. Every time you walk towards something that isn't right, you're one step closer to something that is very wrong. And it baffles me and it bothers me that the teacher, at least this one, was in on it and excited about it, because I don't believe that that creates an overly great example for the youths. Michael?
Daniel, we did talk about this a little bit on In the Blind yesterday, and especially after the show. And we talked about, the fact is the school ostensibly sanctioned this behavior. I mean, if this was well known across the school, this was something that other teachers were engaged in. Obviously, the administration either had to know this was going on or should have known this was going on. If this was such a thing where, there was a point system, and this was obviously something that had been going on for a while. It's kind of like when we hear about hazing and those kinds of things that are happening, and then everybody runs and hides and claims that they knew nothing about it. But then the more you investigate, the more we find out that everybody knew about it and was in on it. And it was like, hey, just a rite of passage. And then the people that were part of it at one point say, oh, come on, man, it's not that big a deal. Yeah, it's not that big a deal until somebody dies or gets seriously injured. And now everyone has to play CYA. And that's where we're in the CYA phase of this now. But I guarantee you there's going to be litigation. There's going to be investigations. And I said it. I don't know if I said it on the air or off the air or both or whatever. I lose track too. But I think anybody that had knowledge of this and was involved in this kind of behavior ought to lose their jobs.
Yeah, I think you can make that argument, Michael. I'm having a hard time wrapping my brain around it. And again, I know there are people, and I've seen in the chat, Tim, tradition, we did it in the 60s, 70s. I get all of that. However, this is another example, and I don't know a better way to say it than how I just said it a few minutes ago. If you take one step towards something that is not right, you're one step closer to something that is very wrong. And I don't think that's a lesson that we're teaching.
Yeah, and let me just say this. There's a big difference between students TPing a teacher's house, okay, and students doing that independently and, we're TPing or egging a house. It's not great. It is vandalism and stuff, but okay, whatever. But then teachers going, hey, I'm going to lie in wait because tonight is the night I know they're coming because this is a thing. It's our game that we have where we have like a point system. And if I catch them in the act, they lose points and we all have a good chuckle about it the next morning. And, there's a huge difference between the two. I get it. I get teenagers are going to do teenage things. This isn't so much about the teenagers. I mean, yeah, there's obviously going to be an investigation into their role in this teacher's death, but I think the much larger, that's a symptom of the problem. The much larger issue is going to be investigating who else knew about this and engaged in it and encouraged the behavior. And, you could say, well, it's TPing, Mike. I mean, no one gets hurt TPing. Yeah, until this person did. And besides that, as you said, Dan, it's like there has to be, and you said this yesterday, I think after the show too, there has to be a separation between teacher and student. There has to be like this boundary that's clearly set. If I saw my teachers out in the wild when I was in elementary or middle school, you said hello and stuff, but we didn't hang out. Okay. We didn't go to the movies together. We weren't buddies. My parents weren't buddies with them. There was a boundary there because there has to be a boundary there. There's supposed to be. That's the other problem that I have with all of this.
Yeah, no, that's just it. There's no boundary. And you can say, oh yeah, there's boundaries, really. Look at all of the court cases. And there was 4 separate stories that I could have pulled up today about teachers who did adult things with their students.
Yeah.
And I chose not to. But I was thinking about bringing it up to kind of reinforce this, but we see this all the time, so whatever. But we have teachers and students crossing that boundary all the time. It's to the point where the boundary is at least blurred, at the most no longer exists. And then we have parents who have just completely turned over the raising of their children to this group. And I'm not trying to throw teachers under the bus. I'm really not.
Absolutely not.
But in the same respect, we have to have some level of monitoring, some level of accountability. And I'm sorry that teachers are underpaid. I'm sorry that they're overworked. It sucks. But if you choose to do that job, you have to be held and hold yourself to the highest of standards. It's just the way it is. And if you can't do it, don't do the job. And I'm sorry if that sounds harsh, but we're talking about forming human beings here. We're talking about young, impressionable minds that have to be led in the right direction. And again, I'm sure there's people out there going, well, Dan, it was just TPing. I get it. But it is, again, it's an encouragement of a not right behavior.
Right.
And
That's
we
the
encouraged
part.
not right behavior, and
Yep.
now here we are.
That's the part that's the problem. If this was a story about teenagers TPing and the teacher didn't know about it and it was just one of those things and, you know, he ran out there to try and stop him and he fell and he died, that'd just be the end of the story. Tragic. Kids should be prosecuted. End of story. Not much to talk about. We probably wouldn't even bring it up, or maybe just as just a sort of, oh yeah, and then this happened. But the fact is that when it's an encouraged behavior by adults, you know, the problem with that too is what kind of message does that send? Like, okay, we're going to take off points if you get caught, so don't get caught. So it's okay to do stuff that's kind of illegal because, again, that's, you know, you could call it vandalism. You could even call it criminal damage, depending on what it is you do. We're saying that's kind of okay as long as you don't get caught. Like, what kind of message is that sending? I guess, and I'm not trying to be the morality monitor here. Like, you know, I'm not trying to, you know, bring a Karen storm in here, but it's, somebody died and people knew about all this going on. And I don't know, would I feel good, or let's, you know, those of you that may not think this is such a big deal, if you sent your kids to that school, would this be something that you were okay with your kids learning, especially when, sorry to get big on the soapbox, but, you know, the United States, it's not like we're top in math and science. It's not like we're leading the world in the most educated people on, you know, globally. You know, maybe if we spent more time on arithmetic and algebra and, you know, on literacy and on history and physics and chemistry and less time on, did you TP his house? You know, if we spent, you know, if we re-diverted the priorities here, or diverted the priorities, maybe we wouldn't have stuff like this happening. I don't know. Maybe we'd be better at globally in education. I don't know, but that's where I'm at on this, Dan. And I know we talked about this so much the last few days. I gotta believe you're kind of there, also.
Oh yeah, you said you didn't want to be the morality police. I will be. Right is right. It is just that simple. And I say that as a flawed human being who makes mistakes every day,
right,
and understands and acknowledges that everybody else does too. But that does not mean you set up the behavior. You know, bad behavior, making bad choices, that's the exception, and you manage and deal with the exceptions. You don't make it the rule, but they set up a damned point system.
It's hazing. It's the hazing story all over again. Just instead of, you know, students, you know, beating each other, or, you know, and a coach standing by and watching, it's like encouraging vandalism of property, but it's okay because the teachers are in on it, kind of, sort of. But maybe, like, then you get into the other areas of like, well, maybe this teacher's wife wasn't in on it. And, you know, now her husband is dead. And now she's having to learn that her husband was like involved in this kind of a thing. And now, you know, what is a tragic death to her is being minimized because, well, he sort of was involved in this kind of thing and tried to engage in it, and you know, an accident happened. And obviously these kids didn't mean to kill him. And that it is still a tragedy nonetheless. I mean, regardless of how we feel about it, it's still very, very sad. But, you know, now there's a lot of questions that have to be answered now, all because people wanted to be stupid.
Yeah. So Tim is clapping back a little bit in the comments, and I don't blame him. He's saying, you know, there was no malicious intent.
Right.
And I totally agree. There was no malicious intent. However, just because there was no malicious intent does not make it right. And something that was portrayed, obviously, because there was a point system, portrayed as to be good fun or sporting or whatever word you want to put to it, you know, was one step into something that was not right, and it ended in a tragedy. But this is the lesson that I wish more and more people would get, is every time you make a step towards something that isn't right, you're one step closer to it going haywire. And heaven forbid that it should ever happen, but it can. And here we are now. This kid's life, who ran that guy over, is forever changed.
Yes.
He will carry this with him regardless of his sentence, regardless of whatever. He will carry it with him until the day he dies. That family, you know, that Laura, the teacher's wife, and they had 2 children, their lives forever changed. And for what?
Right.
For a stupid thing.
Right.
That, you know what? If you wanted to have some kind of student-teacher bonding, find another way. Get out onto a field and go teachers against students in flag football or something. I don't know. But this certainly isn't the answer because, again, it's one step into something that is not right.
Well, and it was off school property. It was after school hours. You know, that's the other thing. You know, because somebody will inevitably say, well, what if they played flag football and somebody fell on somebody else and broke their neck or what, you know, but that's a lot different. And again, I'm not saying this student that ran over
pomegranates.
Right. I'm not saying this student that ran over the teacher is a monster. You know, here on TCF, we have there's a lot of black and white. Okay. There's a lot of, you know, this person did child stuff. This person did murder. This person, you know, had 32 theft convictions. You know, that's all just stuff we can put those people in a box and say, okay, obviously wrong. This is one of those that, yes, it's wrong, but these are not absolutely like the dregs of society. These are kids that did something that kids do. And then because adults got involved and tried to encourage the behavior, something bad happened. Hey, we wouldn't even be talking about this if the guy didn't get run over. Of course not. It'd probably go on and nothing, as long as nobody got hurt, this would be something that went on at the school and it was a fun thing and la-di-da. And I don't, you know, and I guess as long as no one gets hurt, you know, people would say, well, what's the problem? But this is where the problem is, because there's always that one case scenario where, well, then what happens when it does happen? You know, what happens when this does occur? That's the problem here. Again, I don't want to demonize the kids for being kids. You're right, Dan. That kid's life is forever changed. He'll never be this. Who knows if is he going to go to prison? You know, is he going to, whatever the case, whether he goes to prison, endangerment.
We lost Michael.
There I am.
Okay, now you're back.
Whether
he goes to prison was last.
Yeah, whether he goes to prison, charged with negligent homicide, or doesn't, the kid's conscience, his mind, he's forever going to think about that. So, you know, that's the issue, Dan. That's the other issue, is there's lives that are forever changed as a result.
That's just it. And I mean, look, accidents can and will happen every day, and we're not going to engineer that out, nor do I want us to. On another discussion, I feel like we've gone too far in engineering out accidents because it's like a crime to let your kid play outside now, which is just absolutely ridiculous. But there's a difference between that, a legit accident, like you said, with a flag football idea. Well, what if somebody falls and break their neck? Well, that's an accident. And this technically is an accident too, but it is an accident born out of a wrong thing.
Right.
It is a wrong thing.
Right. And not bad intention.
It's a minor wrong thing. Yeah. It's not the crime of the century, obviously, but it is one step into an unright territory.
Yeah.
And that's all it takes sometimes.
Yeah. And I think the other thing is I know what's going to wind up happening is, you know, this is going to descend. The lawyers, of course, whenever they see this, they salivate. And in the courts, we're going to see, you know, there's going to be civil cases up the yin-yang about this, I'm sure. And there's going to be, because the kid that ran over the teacher. I mean, I'm sure that family will probably wind up suing the school because it sanctioned and encouraged the behavior. But for that, the kid wouldn't have done it. And we're going to see all that go on too. And that's the other kind of dark side of this. And this will not get resolved for probably 10 years or more. And, I feel really bad for all the parties involved in here. I really do. But yeah, it's totally preventable. I know when we were kids, and I know, look, Dan, you and I grew up in this time where there was dodgeball and they don't play dodgeball anymore. We don't throw those dodgeballs hurt. When they hit you in the groin, I mean, you were down for 5 minutes or more. I mean, it was a different time, man. And I'm not saying we take away everything fun and we stop having PE and we stop doing stuff because somebody might get hurt, because that's in a sanctioned thing. Like, this is school. There's physical activity. There's exercise. Somebody could pull a muscle. Somebody could fall. Somebody could break a bone. Somebody could get hurt. When I broke my right arm, 40 years ago, it was on school property. I was playing on the monkey bars. And, when we were kids, all the playground equipment was like friggin' steel. It was iron, like the wrought iron, steel. It was completely crazy that was the equipment we had. But nobody intended for bad things to happen. And generally speaking, my parents didn't sue the school because I got hurt on school grounds. It's just a different time too. So there's just a lot of other considerations you have to have, and you kind of have to read the room or read the society the way trends are now before you engage in this kind of behavior.
Totally agree. I will leave you with that last word. Michael, you get that last word. Thanks for joining me.
Thank you so much,
It was good
Dan.
talking with you about this.
Yep.
But I agree with you. Tragedy.
Yes.
All right, friends. So that's the update on that. I'm going to continue to keep an eye on this case and see where it goes. I'm hoping that they don't throw the book at this kid, especially since the family is saying that's not what they want, because I don't think it helps anything. In the same respect, there's got to be some kind of punishment, and I agree with Michael that I don't think the punishment should stop at this student. I think if there were faculty members that were involved, which obviously there were because there's a point system that's been established and the teacher was excited to catch him in the act, so he knew it was coming. There has to be better than that. I'm just saying. But, if you have different thoughts, feel free to share them with me. All right, folks, we'll be back tonight for Sidebar on this channel, 8 p.m. Eastern, 5 p.m. Pacific. Please do join us. We're going to talk about the streaming of courts on YouTube and have a good discussion on that. And then we'll be back tomorrow morning for the morning live show, 9 a.m. Eastern, 6 a.m. Pacific. Tomorrow is Friday already? Tomorrow is Friday, so Super Friday tomorrow. So join us then. In the meantime, go have yourselves a great day. Take care. God bless.